Let's kindly leave to mention one contempt for inclusion.
Inclusion.
Contempt.
May permitted to mention one extension of interim order, my lord. Initially.
Give us but subject to losses, kindly was mentioning this matter for extension of interim order.
Give us.
May I pray for leave to move one application, my lord, urgent matter, my lord. My lord, petitioner is a constructed G+2 storied building after obtaining sanction building plan from the municipal authority. My lord, he constructed according to sanction building plan. My lord, suddenly the petitioner received one vacating notice that the unauthorized construction will be demolished. My lord, already, my lord, on 9th of October, my lord, the demolition squad of the municipal corporation came and demolished some portion, my lord, and they say again they will come this week, my lord.
That means there was some unauthorized construction in your property.
My lord, before that, my lord, no notice of hearing, no inspection, my lord, nothing has been given. My lord, the petitioner constructed according to sanction plan after obtaining the sanction plan for constructing G+2 storied building. I have annexed all that document, my lord.
And how many floors you have constructed?
Yes, G+2 storied building. Sanction, obtained sanction, G+2 storied building. My lord, before that, no inspection, no opportunity of hearing, nothing has been done, my lord.
My matter is similar matter, my lord. No opportunity of hearing or no opportunity of
Sanction plan.
Huh?
You have a sanction plan.
sanction plan. I have annexed my G+4 building. I have constructed according to the construction. Leave to file and move before your lordship.
My lord, may I permit to mention may I permit to mention one illegal construction in our land, my lord, without any plan sanction, my lord.
Give your slip, sir. Give your slip.
Lordship, kindly consider, Lordship, item number 332 and 333. Lordship, what happened? I have purchased both the plot, Lordship's adjacent plot for erecting commercial building. Lordship, what happened? I have superseded the amount of political leaders for which arbitrary municipal authority not issuing mutation. In favor of vendor, mutation is there, but Lordship not consider in favor of purchaser. I have.
May I be permitted to mention, Your Lordship? Lordship, the urgency of the incident matter is that another writ petition has already been disposed of by the by Your Lordship, Your Honor. And Your Honor, I'm mentioning this matter for the inclusion of the same as motion in the list, Your Honor.
Give your slip.
My lord, may be
Deeply
permitted to
grateful.
mention one matter, my lord. My lord, this matter pertains to correction in the birth certificate of a minor girl, my lord, who is presently studying in class 9 and her board exam registration of board.
May I be permitted to, Your Lordship, there is item number 2814 of the monthly list of September. Your Lordship, the petitioner has filed this writ petition because there was an illegal construction that was being made in his plot, and the KMC had inspected and had declared the construction to be illegal and unauthorized. Yet no demolition or other processes have not started yet.
Give your slip.
Please, my lord. My lord, I crave to mention a matter for writ petition for inclusion in the list.
Give your slip.
Much obliged.
Lordship, may I be permitted to mention one matter, my lord? The urgency in this matter is, my lord, we have purchased a plot of land, 96.22 decimals of land, but it has been 2 years. The Raghunathpur municipality declined to give us a simple application form for obtaining holding numbers, my lord. Therefore, we are compelled to file the writ, my lord. My lord, kindly be for inclusion, my lord.
May I be permitted? May I permit to mention a matter for inclusion?
Give your slip.
May I be permitted, my lord? It was listed in the vacation bench because of dearth of time, or court was not kind enough to take up this matter, my lord.
Give your slip, we'll see that.
I'm just landing.
My lord, may I be permitted to mention? This is a pre-filed writ petition challenging inaction of the Khordha municipality of unauthorized construction. But recently, since last 7 days, I am unable to enter into my house due to accumulation of building materials and encroaching my pathway, which connects my premises with the main road. By
Give your slip.
my lord, kindly fixes any day at the top. I will serve notice today.
How are you mentioning without informing them?
My lord, this is today is the first day, my lord. Other side, this is my lord a new motion matter. I do not know who is appearing for the state, but I will inquire today and serve notice accordingly. Deeply obliged.
It's not the first day. Court opened on 24th.
May I have my lord's kind leave to mention one matter, my lord?
Yes.
Lord, I'm praying leave to mention one matter, my lord.
Yes.
This is a motion, my lord, which was heard on 4th September 2025, and there is a direction for filing the affidavits by the parties.
Yes.
My lord, the affidavit has not yet been filed, my lord. I'm seeking demolition of the unauthorized construction, my lord, which is raising on the ground floor of mine, my lord. I am the occupier owner.
Give your slip.
Yes.
Call out the matters.
I am for the petitioner.
Yes.
I am for the petitioner, but I have copy. Then, very good, very good, petitioner. Good.
No, no. My lord, I'm appearing for the municipality, my lord.
I made objection because you are to kindly write. Page 14, my lord. Made objection that was not considered, my lord.
Sorry?
Page 14, 1-4. For instruction, the illegal construction. But that was not considered, my
My lord, let
This
the
is-
chairman be considered the representation, my lord.
Chairman.
Yes, sir. Will direct.
Not considered by the chairman, my lord. Not taking any hearing, not consider my representation, my lord. So I pray for your lordship to consider my representation.
Take down.
Okay.
The petitioner has preferred the present writ petition
Aye.
being agreed by the inaction
Aye.
of the respondents
Yes.
in not taking any action for the alleged illegal and unauthorized construction being carried out at premises number 39A and 179, Devi Nivas Road, it's only premises number 179, right? One premises or two premises?
Oh.
At page 17, you're also alleging 39A.
Holding 179.
Only 179?
179. Got road, yes, come down, now Nagar Bazaar.
Only 179?
Yes, my lord, only 179.
179, man.
Apni do-
Holding.
See page 17.
39A.
Sir, it's your brief. You're not even aware of the properties against which you're alleging unauthorized construction.
39A লেখা আছে।
There are two properties, sir.
এখানে দেখুন, এখানে Oh, 39A belongs to the plot of the petitioner, my lord.
Paragraph 4, my lord. That is clear. Paragraph 4. It will say that the private respondent being a number, yes, my lord, constructed The multi-story building at permission number 39A, Desmond Road, and also premises number 179, Tribunal Road, now Nagar Bazar Police. Ward number 22, Domdom Municipal, without any proper sanction plan and without common space as per Municipal Act. Paragraph 4, by
Page.
page 4.
So there are two properties.
Yes, sir.
There are two properties.
Yes, sir.
Illegal and unauthorized construction. AN 179, Devi Nivas Road, comma, New Nagar Bazar, PS, Damdam, Calcutta, 74, at the instance of the private respondents. Full stop. It is the case of the petitioner that he is the absolute owner and resident of premises number 253, comma, Devi Nivas Road, comma, New Nagar Bazar, comma, PS Damdam, full stop. He states that he had constructed a residential building therein after obtaining due building sanction plan, full stop. He states that the said illegal and unauthorized construction is causing inconvenience to his plot of land. Full stop. It is further submitted that he further submits that the private respondents are carrying out the said unauthorized construction without leaving any mandatory space on the sides and in utter violation of the building bylaws, full stop. Despite filing representations dated 18/8, despite filing representation dated 18/8/2022, comma, no action has been taken by the respondent, full stop. Learned counsel for the respondent. Which municipality is this? South Damdam. South Damdam
Municipal.
is Maushami Bali states that they are ready and willing to consider petitioner's representation within a time bound representation, full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is considered within a time bound manner, full stop. In view thereof, the presented petition is disposed of with the direction to the respondents to consider and decide petitioner's representation dated 18/8/2022 within a period of, Ms. Bhavani,
My lord, 4 weeks.
within a period of 6 weeks from the date of communication of this order, after affording an opportunity of personal hearing to the petitioner as well as the private respondents or any other stakeholder by way of a speaking order, full stop. With the above direction, the presented petitions. Who should consider it, Ms. Bhavani? Which respondent?
Yes, my lord. Respondent number 3, my lord. Chairman, respondent number 3.
The chairman or the executive engineer? Chairman.
My lord, chairman. My lord, the board of councillors will take the decision, my lord.
Chairman.
Yes.
Affidavit of service, take it up.
Get to it.
My lord, in this matter, Subhobroto Datta is appearing for the petitioner. He is on leg at code number 26, my lord. Kindly make it short pass over.
Not today.
Great.
Lord, I have instructions to withdraw the matter.
Who are you? Why did you file this petition?
My lord, a building was constructed in front of my building, my lord. The window of that building, my lord, it was violating the open space, my lord. My lord, that has now been resolved, my lord. After the writ petition was filed, my lord, that has now been resolved by the NKDM, my lord.
Learned counsel for the petitioner seeks to withdraw the present writ petition. The same is dismissed as withdrawn. Instructions received from the client is taken on record. Instruction to withdraw the writ petition. Yes, Mr. Banji.
For the respondent, my lord, the allegation is that on 2023, we have demolished a portion of the unauthorized construction of the building there. So now they have challenged that. We have already handed over them a 10,000 rupees construction demolition cost, and thereafter we have again given them a demolition notice, vacating notice that some unauthorized construction required to be further demolished. I have the report, and now they have filed after.
But is here not today? Not today.
Item number 5, my lord, I am for the petitioner. My lord, this illegal construction has been made. Corporation has not taken detail of the unauthorized construction. My lord, kindly sees this entire without any sanction plan. A 4-storied building has been constructed on a Tika tenancy land, and without any sanction plan, and even after corporation directed the ordered the unauthorized construction to demolish it within 30 days, the KMC authority has not done anything after that.
Where's the demolition order?
Kindly, my lord, I have handed it over before your lordship. There is the after the writ was filed, this hearing was done on 16th May 23.
So this has already been satisfied. If you want
no, my lord, kindly, no, my lord, it's not been satisfied.
What are your prayers?
My prayer is that to demolish the entire building. It's unauthorized construction. Corporations have not demolished it. My lord, kindly.
Wait a minute, sir. See your prayers.
Last one.
Eight, my lord, prayer B, my lord. To cause the demolition of the illegal and unauthorized construction being carried at on premises number this in that.
To stop the further construction. Which
Stop
has
the
been
further
done.
construction, all that.
Order has been passed. Ask for an implementation of the order.
But
all right, ask for implementation of the demolition.
Yes, my lord. My lord, kindly direct them to implement the
I will not direct it in this writ petition. File a separate writ petition. Learned counsel for the petitioner has Referred the present writ petition.
Hearing has been done after we have filed this writ petition.
So they have acted upon it.
They have acted just giving a notice.
There is a provision for appeal, your lordships kindly see the last paragraph of that. That direction was there. Any person aggrieved by the order, my lord, that is there. Always there, because 400 subsection 1 order was passed, 400 subsection 8, he can prefer an appeal if he agrees.
He is not aggrieved. Why will he be aggrieved? He is the complainant.
He is the complainant because,
Why
my
will
lord,
he
the
be
order
aggrieved?
is not in his favor. My lord,
The order is in my favor.
That is in his favor, sir.
in his favor. So what remains? My lord, I
Remains the
Remains
demolition.
wants
They are not
demolition.
demolishing and totally illegal construction, my
Well,
lord.
separate
And
cause
they
of
will not. They have
Right.
taken.
It is
They
a
are,
separate cause of action. That's what I'm telling him.
My lord.
That's why I'll
my
dismiss
lord,
the writ
no,
petition.
my lord. If it's a separate cause of action,
It is a separate cause of action.
yes, my lord. But I have prayed before your lordship to demolish.
Don't worry.
Your lordship has the power to give it.
You want to withdraw this, file another writ petition, you can do that, or I'll dispose it off. Whatever you want.
As your lordship directs, I will go down to your lordships. As your lordship.
Withdraw this. Learned counsel for the petitioner states that he had preferred the present writ petition, seeking demolition of the seeking action against the alleged illegal and unauthorized construction being carried out at premises number B3A/H/10 Gorba Goshen Road, Ward number 59, Borough 7, KMC, under the KMC, Calcutta Municipal Corporation. Full stop. The learned counsel for the respondent submits that they have acted upon the complaint of the petitioner and has passed a demolition order dated 30th/8/2023. Full stop. He further assures this court that necessary action shall be taken in compliance of the said demolition order in accordance with law as expeditiously as possible. With the above direction, the present writ petition is disposed. All right, you got that direction, sir? I've given them the direction, they'll act accordingly. Take line ad, copy of the copy of the demolition order is handed over and the same is kept on record. From the order, it is reflected that the said illegal and unauthorized construction was carried out without any sanction plan. And thus the respondent has passed an order for demolition of the same. Yes. Next. Who's there for the petitioner?
7, I am for the respondent municipality, my.
7.
In this.
Now then is 6. Item 6.
6 tables.
You are appearing, Mr. Manager? None for the petition. Not today, girl.
I'm appearing for the respondents 5, 6, and 7.
Petitioner for the Howrah Corporation. On the last occasion also petitioner did not appear.
There is no scope for anything. Everything, there is no infirmity detected. Everything is over, my lord. And there was a previous petition at his instance.
Allegation is that
On the self-same
construction is
cause of
made on a land which is not owned by the private.
None for the petitioner.
I'm for the corporation.
Even on the earlier occasion, there was, even on the earlier occasion, 2/8/2025, there was no appearance on behalf of the petitioner. The present writ petition is dismissed.
Actually, today is for
44.
no adverse order. Yes, bro.
Today?
That is a. There is a resolution.
There's a resolution. I'm not
So
aware.
I think the order may be passed if your lordship
Not
to
today.
retire.
Mr. Bhattacharya.
No.
Today itself it has been. I'm for the
Kindly, my lord, kindly keeps it next week or kindly passes directions for affidavits.
No, affidavit cannot.
What is the point? He's not appearing last also occasion.
No, then kindly keeps it on Friday. Kindly keeps it on Friday.
I'm not keeping it.
No, again, tomorrow there is a resolution.
I will not be there, my lord.
Friday next week.
Next week.
Next week.
Next Monday.
Monday.
Next Monday.
Next Monday. Not this.
No, ownership dispute, no, there's no point.
No, I was not aware about the resolution.
Me too. I'm not aware of this.
No, I am aware.
Thank you.
No, one formal order your lordship has recorded. No, otherwise,
None for the petitioner. In the interest of justice, adverse orders are deferred. Let this matter be listed on Monday.
Great.
Howrah Corporation.
We appear with the state respondent.
Application for addition of party in this matter. And I understand, my lord, the petitioner has expired, one of the petitioner. The Pradip Hajra, my lord, so far my knowledge goes, he has expired. And my lord, I have filed an application for addition of party in this matter because I am the.
Who's for the petitioner?
We have the state respondents.
Who's the petitioner?
None is appearing today.
Not today.
Not today.
Well, I'm for the petitions. Well, this is affidavit of service. Well, involved in this writ application, my lord, change in the holding name, my lord. The originally the property belongs to, my lord, our predecessor in interest, my lord. The private respondents are also the descendant of our predecessor in interest, my lord. My lord, kindly come to page 62 once, my lord. Annexure P6.
Yes.
My lord, can you see that holding number is 14 and it is name of the assessee Ramkinkar Daw and others, my lord. My lord, this Ramkinkar Daw is the predecessor of the petitioner as well as, my lord, the defendants, private respondents, my lord. My lord, kindly comes to page 74 now. My lord, in 74, my lord will find the holding number 14, my lord, just below the names, my lord, the same holding number, my lord. And now, my lord, this has been, my lord, transferred in favor of the private respondents, holding that they are the legal heirs of Gurupada Daw and Mayarani Daw by virtue of one deed, my lord. My lord will find one deed, reference of one deed number, that is deed number I-1771 of 1942, ADSA DGR, my lord. My lord, by virtue of this deed, my lord, this gentleman, Gurupada Daw, my lord, became the owner. Subsequent to that, my lord, there is one deed in favor of Ramkinkar Daw, my lord, in whose name the holding stands, my lord. One, my lord, deed of relinquishment in favor of Ramkinkar Daw by this Gurupada Daw, my lord. Therefore, this deed is no longer, my lord, operative in view of the subsequent deed of relinquishment, my lord. So we raised objection, my lord, since 2020, my lord. This has been done in the year, my lord, 2023. But, my lord, prior to that, my lord will find from 75 onwards, my lord.
Yes.
In the year 2020 onwards, my lord, we have raised objection not to change the name, my lord, in favor of the private respondents. So far, the holding number is concerned, my lord. That was not considered, my lord. No opportunity of hearing has been afforded to us, my lord.
Yes.
And subsequent to that, my lord, we have filed one civil suit and there is one injunction order. My lord, I am not on that, my lord, civil court order. My lord,
Who is for the corporation, Durgapur?
my lord.
Who's for the corporation?
My lord, rules, today I am not having this with me, my lord, the rules of.
No, who's appearing for the
Who is
corporation?
appearing, my lord? I have served, my lord, I have given intimation, my lord, that this matter will be mentioned and my lord has been mentioned and it is in the list, my lord. I have filed
Serve them again. Serve them again, not today, next week.
Not today, my lord. My lord, in that event, my lord, may I serve a fresh notice upon the state?
Absolutely.
My lord.
Not today.
Yes, my lordship, I'm for the petitioner.
And I am for the Kolkata Municipal Corporation.
I'm for the state.
Yes.
My lordship, I am from 2099 various representation, made various representation before KMC, but they never took appropriate steps. The unauthorized demolition, unauthorized construction is continuously going.
Lordship, kindly see page 4 of paragraph 5.
What happened to the earlier writ petition? You had filed a writ petition earlier also, madam.
Yes, my lordship, in 2019.
Lordship, kindly
Where
see
is that?
page 4, paragraph 5. Already
Paragraph 5.
paragraph 5. Already proceeding has started. Corporation has started proceeding.
That's right, but what happened?
Yes, my lordship, they had started proceeding from 2020.
Madam, first tell me you filed a earlier writ petition 17878 of 2019.
It is still not pending, my lordship.
Then how can you file this petition? How can you file this petition if that is pending? Then you withdraw this writ petition, madam. If a petition is already pending, you can't file a same petition for the same cause of action. You keep filing petitions.
Yes, my lordship.
You withdraw this. Learned counsel for the petitioner seeks to withdraw the present writ petition. The same is dismissed as withdrawn.
No copy of the supplied.
Petition, no pending, my lordship.
তো তুমি বলেছো তো বলো না সাপ্লাই
My lord, dismissed as withdrawn.
Dismissed as withdrawn.
Supply
The
করে।
petition is already pending for the same cause of action.
এই petitionটা কি এখনো pending হয়ে আছে?
দিয়ে দিয়েছে কি হলো এটা?
Dismissed. একটা petition pending.
Not today.
Lordship, I am for HMC led by Mr. Sandipan Banerjee.
But on the last occasion, your lordship directed Mr. Banerjee to submit a report, my lord, by 17th of September, my lord, matter art, my lord. The report, I have not received any report, my lord, in the form of affidavit, my lord. That was my lord's direction.
They have filed their.
Kindly fix the second up.
Why? What happened? They have not filed the affidavit.
No, my lord, I have not received any report.
Where's the affidavit?
I have no direction, lordship. Kindly fix it second up.
Not today. Tomorrow we'll have.
Lordship, I beg to appear on behalf of the petitioner.
13, my lord, I am for the private respondent, my lord. I am yet to obtain the Mokadama. If your lordship kindly, my lord, adjourn it for a week, my lord.
Let me hear him out.
My lord, this is my affidavit. My lord, in 2022, my lord, if my lord may kindly takes page 4, paragraph 4, my lord, of my pleadings, my lord. My lord, in 2022, my lord, this private respondent, my lord, started illegal construction, my lord, and erected a permanent structure on the open space of the ground floor of the premises, my lord. Subsequent to it, my lord, a representation was made by the erstwhile owner, my lord, which will appear at annexure P1, page 15, my lord, in the year 2022, my lord. P1, my lord, the earlier owner, my lord, made the company, my lord, made a representation for taking action against the illegal structure which was erected upon the common premises, my lord. Now, my lord, in 2023, what happened? This private respondent again, my lord, erected a illegal structure on the second floor of the said premises, my lord. My lord, I have annexed the photographs, my lord. That will appear at, my lord.
Yes.
Page 17 onwards, my lord. Page 17, 18, 19, 20, my lord. Now, my lord, these illegal.
It's like an old structure.
My lord, I am under the corporation, my lord.
Yes.
As per my instruction, it's a dilapidated construction, and corporation has allowed under section 411 subsection 1 to repair that
My lord.
construction.
My lord, repairing is something else. We, the owners of the premises, we, the owners of the premises, are carrying out the reconstruction or repairing work as per the sanction of the corporation. Now, this private respondent and my lord illegally carrying out everything, my lord.
There is nothing illegal. What is it?
My lord, kindly takes the pictures, my lord. Kindly.
That's what I'm looking at, page 17.
Yes, my lord.
What is the illegality?
My lord, this is not the part of the original structure, my lord. This has been erected subsequently, my lord. This is not the part of the original.
What erected? This is nothing. This looks like a box.
Now, my lord, these are the staircases which leads to up and front. These are old buildings in the Bada Bazar area, my lord. Now, ingress and ingress is completely end. The drainage system here is blocked, my lord.
Where does it show that the drainage system is blocked?
My lord, kindly sees the drainage passes
This is
underneath
no construction at all.
My lord, these
pictures which you are showing me, this is no construction.
Now, my lord, kindly takes the last page, my lord. This is the open space, my lord. Kindly see. He has put the erected a structure over there also, my lord. Page 90. My lord, this
no structure. Not a structure.
Now, my lord, these are the permanent things that they have been erected, my lord. These are not the part of the building, my lord. Upon the drainage system, he has built this all.
These are all the top. How can you say it's drainage system? Where's the drainage system in?
My lord, it is beneath it, my lord, as I've been instructed, my lord.
How can it be beneath it? This
now,
is
my
the
lord,
second floor.
kindly allow me to file one supplementary, bringing on record all the fresh pictures that showing that these structures. Kindly allow this, my lord, to file
Why
one.
should I allow you to file supplementary affidavit for no reason? There's nothing in here. You file a better writ petition, withdraw this and file a better writ petition with better particulars. I'll give you that liberty. Learned counsel for the petitioner seeks to withdraw the present writ petition with liberty to file a better writ petition with better particulars.
Grateful, my lord.
Liberty is granted. Present writ petition is dismissed as Withdrawn. Not today.
Item number 15, my lord, I am appearing for the municipality.
I am appearing for the private respondent.
My lord, advocate on record in this matter, my lord. He is suffering from fever, my lord. Therefore, I am paying for not this week, my lord.
Not this week.
Equal, my lord.
But I am for the private respondent.
I am for the petitioner.
Fine. But kindly sees the last order.
Yes.
I am for the petitioner. My lord, initially, my lord, the complaint was made before the municipality for illegal construction. My lord, prior to that, petitioner made an application, my lord, under RTI. My lord, whether there was any plan or not, your lordship will find page 21, my application. Thereafter, the municipality replied, my lord, page 23. If your lordship kindly come to page 23. My lord, it was written, verified available municipal records from April 2015 to till date, it has been found that no such plan was sanctioned in favor of the holding within that period. But thereafter, my lord, page 24, my lord, I made another application against such illegal construction. My lord, municipality did not take any steps. My lord, next, my lord, page 25, I filed a writ petition. My lord, writ petition was disposed of. My lord, relevant portion is page 26, second paragraph. In view of that order, my lord, inspection was made. But my lord, as there was a direction, after inspection, copy of the inspection report should be served upon the parties. My lord, no copy has been served, but they called for hearing. My lord, kindly come to, my lord, page 30. This is the impugned order, my lord. May I read, my?
Yes.
My lord, heard both the parties and read with the inspection report from which it appears that building was constructed over holding number such and such by Srimati Shanti Devi in long back ago, approximately 20 years. It is admitted fact that there are some deviation, but after prolonged period, this construction cannot be stated as illegal. In this respect, a plan was sanctioned on 25th April 2000. My lord, in this way, my lord, they are avoiding my lord the situation because my lord, my specific case is construction was started in the year 2016. Thereafter, I take steps, my lord, against the illegal construction. My lord, now this fact has come from the part of the municipality. My lord, on the other hand, they have admitted there is a deviation that cannot be, my lord, stated as illegal. My lord, I am challenging this order.
But as per last order, but the allegation which they have brought in the year 2016, there was some plastering work was done. But so far illegal construction is concerned, my lord, there is minimal deviation. Law permits me to get my lord, get it sanctioned. My lord, I'm relying on this order, my lord. It has not been.
So did you get it sanctioned?
Yes, my lord. There is notification in case of minor deviation, but can be regularized in municipal
If
areas.
there is any sanction.
Yes, there is sanction plan. Admittedly, I have sanction.
Made an application for regulation, sir.
No, my lord. My lord, so far today is my lord, today I am praying before your lordship that liberty to apply before the concern.
You don't need any liberty. You have to move an application.
My lord,
before
kindly
the
seize the last
authority.
order. So far, last order is concerned, my lord, I am included. But so far, last order is concerned, my lord. Uh, uh, Kindly cease petition is directed to make before and before municipality there is any construction of current. But kindly see the second paragraph. The petitioner is directed to make complaint before the petition before the police and also before the municipality if there is any work, either construction of or closing or plastering in the said building, and immediately after receiving the complaint, the police station municipality shall take steps. As of now, matter is goes out of the list. Private respondent shall have liberty to mention the matter on obtaining either sanctioned building plan or relevant building sanction. But after this, my lord, I did not get the opportunity, my lord. Just I received the brief. I stated my client to make an application, my lord. There is minor deviation, my lord. My house 20 years ago, my lord.
Kindly look into the page 30 of the writ petition. The order passed, the hearing conducted by the Bhatwara municipality, my lord. The order has been passed, my lord. Page 30 of the writ petition. As both the parties read the inspection report from which it is appeared that building was constructed over holding number such and such number 22 by lane, ward number 14, being RS Dag number 1837, RS Kotian number 184 Mouja Kakinara, jail number 12 of Shrimati Shanti Devi in the long back ago, approximately 20 years. Minus 20 years means that the date of conducting hearing 22. Prior to that, 20 years, the construction matter. It is admitted fact that there is some deviation, but after prolonged period, this construction cannot be stated as illegal. And this is respected order passed by the municipality, my lord. But if it is fit and proper, my lord can stand the same. Otherwise, pause the order, my lord. But is a fact, my lord. As per section 90 of the old Indian Evidence Act, my lord, any document for a period of 30 years old is presumed as a evidence. Old Indian Evidence Act 1872. Section 90. But is it 20 years old, more than 20 years
25 years now.
20
5
years old.
years.
This is my submission, man.
What is the illegality? You are saying there's no illegality.
But this is report. In the joint hearing, it is admitted by both the parties that there is some deviation.
But you are saying that the deviation after a period of time has cannot be stated to be illegal.
That portion may be wrong, my lord, but I may be permitted to get it, my lord.
construction in Malad, they did not have any plan, Malad, in the year 2000 also. Malad,
They're saying that they have a plan.
Malad, my instruction is,
I-
Malad, they don't have any.
I
plan.
have my
And
sanction
Malad,
plan.
Secondly, my lord, Malad,
Sir, we will go by what the department says, not by your instruction.
secondly, my lord, the construction was started, Malad, in the year 2016. Thereafter, my lord, I made, my lord, complaint before the municipality.
That is apparently wrong.
I have another intention, my lord, then, my lord, I have purchased the land, my lord, thereafter I can make the complaint. But I did not. My lord, when they started new construction, I made the complaint.
But on the last occasion, they have admitted that was plastering was going on, my lord. Kindly see the last order.
There is no such admission, my lord, that plastering.
And after this order, I did not do anything, my lord. A little deviation, my lord.
But one civil suit is also pending.
One civil suit pending. I have initiated STSC case, but that is the repercussion of this case, my lord.
You filed a.
Yes, my lord. I obtained instruction today.
But another thing is that, kindly page 22, annexure P3. Annexure P3. The right information report.
Yes.
In this case, my lord, page 23, is a reply to the RTI, my lord. Information sought under provision RTI Act, under section 6 by Basdo Shaw. Verified available municipal record from April 2015 to till date. It has been found that no such plan was sanctioned in favor of the holding within this period.
What are you reading? This is against your own statement, the order
Yes,
which you have passed.
But my lord,
You are saying that there's a sanction plan. Now you are reading this. This is your reply, nobody else.
But I am not suppressing anything before this honorable court, my lord. I am the officer of the court.
How are you helping me? By giving all this wrong information.
It's annexed to
Different stands, all your documents.
I have with my sanction plan.
RTI replies, anything is given in RTI replies.
That is wrong.
Yes, what do you want now?
For Malad, fresh inspection be done and fresh hearing be taken by the municipality. Because Malad, we have to challenge the.
You have not challenged the last order. On page 30, you have not challenged that order.
I am challenging this order, Malad. Malad, kindly see my prayer.
This is passed on. What is the date of this order?
17th June 2022.
Where are you getting that from?
June has been challenged.
Page 29, Malad, this order was communicated on 30th.
But it is written over here, my lord, resolution dated 17/6/2022. that date order was passed, my lord.
You are challenging the order dated 30th/6/2022.
That was communicated on 30th.
Where is the date?
My lord, page 29.
No. It's
My-
27/7/2022.
27/7/2022. This was served on 27th. We have received on 30th.
27/7, and you have received prior to that 36.
How is it possible? What are you saying?
June and it is July. Order passed in July, 27 July, and you have challenged the 30th June order.
It is also admitted fact there is a civil suit, my lord, for the rivalry, my lord, this instant case, my
Please
lord.
give the facts clearly, sir. What is this? You're not challenging this order also.
Yes. He is not challenging the order.
My lord, kindly come to page, my lord, 8.
Yes.
Page 8.
It's not in the
Yeah.
prayer.
My lord, paragraph 15.
Yes.
My lord, that from the order passed by the POC, it appears that the order was passed in violation of the direction of the court by suppressing the material fact which was placed before the municipality at the time of making complaint by the petitioner. In the order, it is admitted that there is some deviation of.
Can you please come to your prayer clause? Please read your prayer clause on page 11.
My lord,
Prayer. What are you seeking?
particular resolution cancel which was set aside the decision of the Board of Councillors. This petition and initiate fresh proceeding of the.
What is P6? See P6. Are you seeking
P6.
cancellation of this? Page 28.
Page 8. My lord, kindly see page 8, P6.
Page 8.
Page 8. My lord, before paragraph 15.
Sir, you see P6 on page 28. What is P6?
P6 including my lord, page 28 to
Oh,
30.
this is a different piece of document, please.
My lord, kindly see once. 8, my lord, once.
Sir, will I see your pleadings or not? There's no correlation.
But P6 starts from page 28 to 30.
This is your RTI application, sir. This is your RTI application. Where is the order of 30th of June?
No order. এখানে কোনো order নেই। কোনো order নেই প্রত্যেক দিন। ঠিক আছে, typhoid করতে ঠিক আছে। Leave নিয়ে correction করুন।
Where's the order of 30th of June?
My lord, leave may be granted.
Why should I grant you leave in this? File a separated petition then. Learned counsel of the petition seeks to withdraw the present writ petition with liberty to file appropriate proceedings in accordance with law.
On the same side.
My interim order is, if any, vacated, my lord. Interim order may be vacated.
Obviously, it goes.
Grateful.
I'm going to be.
I am for the KMC, led by Mr. Subramanian.
Lord, I am appearing for the state in this one.
I'm filing
Exception.
reply.
Copy David.
What are you filing, sir?
My lord, affidavit of service and my lord, affidavit in reply.
There is the opposition.
Yes.
সেটাই দিয়েছে।
আমার হয়নি কিছু, রেডি হয়নি।
আপনাকে support ঠিক আছে, হ্যাঁ ঠিক আছে।
My lord, absolutely.
What is this?
This is a supplementary.
Supplementary affidavit at this stage?
This might well also be considered. Alicia. My lord,
Why should I take a supplementary affidavit at this stage, sir?
all right.
Get back to him.
My lord, this matter has to my lord, Jacob history, my lord. Initially, my lord, I made complaint. Report the KMC. No action was taken by the KMC, for which, my lord, I filed a writ petition, my lord. The writ petition was heard, my lord, in presence of the KMC as well as in presence of the private respondent. My lord, an order was passed. My lord, kindly see the order that will be appearing from আমার রেজিস্ট্রেশনের কপিটা কোথায় রে ভাই? হ্যাঁ এটাই, that will be appearing from my lord from page number 50. My lord, that order was passed, my lord. That order was passed, my lord, as per back on 3rd of January 2022. My lord, my lord, the gist of the order, my lord, is that, my lord, that the corporation shall issue notice, make inspection in presence of the both parties, and thereafter, my lord, matter will be my lord, decided by the special officer, my lord. Here, my lord, the order was complied. My lord, kindly, my lordship, well, I am reading the under such circumstances, writ petitioner is disposed of with the following direction. Page, my lord, I am reading, my page 54. An inspection of the premises shall be held. Such inspection shall be held in the presence of the parties within 48 hours advance notice. The report of the inspection shall be prepared and handed over to the parties. A hearing shall be given to the parties. The parties must also be allowed to furnish their written version and make oral submission as also adduce evidence in support of their contention. A written order shall be passed and communicated to the parties on the basis of what it transpires at the hearing, and during inspection, the proceedings shall be reached to its logical conclusion. My lord, this is the, my lord, order, my lord. After that, my lord, notice was issued. My lord, both parties, my lord, attended the hearing, and on hearing, my lord, my lord, kindly see page, next page, my lord. Next page, that is the report, my lord, of the special officer, my lord. As per, my lord, kindly see next page, annexure P6, page 56. As per order of the Honorable High Court, dated 3/1/22, in respect of WPA number, the state of West Bengal, a joint inspection was caused at the caption premises in presence of both parties, and on 15/3/2022,
at about 3:15 p.m. There are three structures within the premises. C4 and C69 are made in of tin sheet over bamboo structure. F 203 and 202 are made of tin sheet over steel structure. Well, this is the minor of the private respondent. There is a steel stair and steel intermediate floor within F5203 and 5202. The iron beams, no sanction plan was produced in support of the said structure. All structures are shown in enclosed sketch map. My sketch map has been given, everything has been detailed here, my lord. Thereafter, my lord, your lordship will get from page number 58 onwards, my lord, the notices issued to the parties, my lord, for hearing, my lord. My lord, page 60 also this, my lord. And the order was passed, my lord. That will appear from page 61. My lord, kindly see. During inspection and hearing, both parties and respondent could not produce any document in support of their structures unless and until Kolkata Municipal Corporation authorized the construction. The same has been declared as unauthorized. Therefore, I dispose of this matter with a direction that both parties and the respondents will demolish unauthorized structure under the possession, this is. But thereafter, my lord, partly demolition was also made. My lord, thereafter another writ petition was filed by the private respondent, my lord, before this honorable court, my lord. Kindly see the order that will be appearing from page 62, my lord, challenging the order of the special officer, my lord. The petitioner is aggrieved, my lord, kindly see, petitioner is aggrieved by the notice dated 20th May 2022 under section 544 and 546 of Calcutta Municipal Corporation Act 1980 issued by the executive engineer. The petitioner has been directed to demolish the said over steel structure made of iron joist at the premises number 98 14 Sen Soroni under the jurisdiction of Kolkata. The petitioner submits that an appeal has been preferred. They have preferred an appeal before the building tribunal. The petitioner submits that an appeal has been preferred before the municipal building tribunal, and the same is pending for consideration. Prior to the appeal being decided, if the demolition is carried out, then the appeal will be rendered infructuous. Learned advocate representing the Kolkata Municipal Corporation has produced instruction before this court from the executive engineer, building department, Borough number 3, dated 4th July 2020, which mentions that petitioner has made massive steel structure with tin shed, covering and steel column and steel roof truss without any approval / sanction from the corporation. Hearing was held under section 401 of the KMC Act 1980. During inspection, the petitioner failed to produce any document in support of the structure. The unauthorized construction has been made in a haphazard manner without following any norms of civil engineering, and as such, it may collapse at any time, causing harm to human life. The petitioner was accordingly directed to demolish the unauthorized construction, but the same has not been demolished till date. The date for demolition has been fixed today, that is on 6 July 22. Considering the gravity of the situation and safety of adjoining structure, as well as safety of public, the corporation has decided to demolish the said structure first. On repeated query from the court, a learned advocate of the petitioner has failed to produce any sanction, public permission in support of the construction that has been made. Accordingly, according to the provision of law, no construction can be made without obtaining proper sanction permission from the concerned authority. The petitioner has not been obtained any permission or sanction from the corporation. Accordingly, there is no reason for interfering in the matter. The petition fails and is hereby dismissed. My lord, first we filed writ petition. Here in the writ petition, they were called to produce the sanction plan that could not be produced. At the time of my lord hearing before the special officer, they could not produce any sanction plan, and my lord, they filed a writ petition here. Here also they could not produce any sanction plan. 3 times, my lord. Thereafter, my lord, they preferred an appeal against that order, my lord. That will be appearing from the next page, my lord. From that order, my lord, your lordship, yes, page 65. My lord, kindly see, my lord, here, my lord, my lord, I am going to the, my lord, relevant portion. Here, my page 67, my lord. On page 67, my lord, last paragraph, my lord, we are of the view that the corporation should stay its hand for the time being till the tribunal disposes of the writ petitioner's appeal. Needless to say, in the event the tribunal dismisses the appeal, the corporation shall complete the demolition activities. If the appeal is allowed, the consequence will follow. We direct the municipal building tribunal to dispose of the appeal as expeditiously as possible. And my lord, before that, my lord, here also, my lord, that in the when the appeal when heard, they were asked to produce the plan that also could not be produced, my lord. Here, where you in the first in the portion of the page 67, your lordship will find that my lord, the writ petitioner could not produce anything before the learned single judge to show that the impugned structures were authorized to or put up after obtaining sanction plan from the corporation. The learned judge refused to interfere and dismiss the writ petition, hence the appeal. We have heard learned counsel for the parties. It is not in dispute that the order of executive engineer dated has been carried in appeal before the municipal building tribunal hearing. We are told that during pendency of the appeal before the tribunal, a part of the impugned structure has been demolished. We are told that July 28, 22 has been fixed as the date of demolition of the remaining portion of the structure. My lord, kindly see. Next, my lord, my lord, kindly see in the page 68, my lord, first paragraph. In the event, for some unavoidable reasons, the appeal cannot be disposed of by the tribunal within the time period indicated above, and the appellant herein, who is also appellant before the tribunal, fails to obtain an interim order of stay before the tribunal, nothing will stop the corporation from proceeding with the demolition work. My lord, this order, my lord, kindly see, was passed on 27th of July 2022. My lord, this has been passed that if, my lord, within a month, my lord, if the appeal cannot, the appellant is unable to bring the stay order, there will be no bar on the part of the corporation to demolish the work, unauthorized work. But nothing has been done by the corporation, my lord. Thereafter, my lord, we are not made parties in the tribunal before the building tribunal. We made an application for addition of party. Though, my lord, at our instance, my lord, the order was passed, we were not made a party. Well, we filed an application for addition of party that will appear from page 69. From that, your lordship will find that we have made an application for addition of party. Subsequently, that addition of party application was heard. My lord, kindly see, thereafter, my lord, after a long gap, my lord, the appeal was, my lord, heard and disposed of, my lord. Kindly see 20, that will be appearing on, my lord, page 76. My lord, order dated 27, 2022. My lord, kindly see the order. My lord, from the very beginning, if we read, it will appear that, my lord, how the order has been passed, my lord, and how, my lord, it has been, my lord, private respondent has been escaped, how private respondent escaped from the order, my lord. Kindly see. By Konda? No. High Court order. My lord, kindly see page 80. Page 80. 69. Page 80. This appeal is directed against the impugned order dated 18/5/2022, passed by the learned special officer building in respect of the premises numbers 98. The allegation against the appellant is that he has constructed a structure by the tin shed in the premises in dispute. The notice under section 401 of the Calcutta Municipal Corporation was served upon the person responsible. They could not be able to produce any satisfactory document in support of the structure in dispute. So the learned special officer has directed the person responsible to appellant to demolish the structure. Being aggrieved by and dissatisfied with the order passed by the learned special officer building, this appellant has filed this appeal on the ground that the special officer has passed the order illegally. That no copy of this sketch map has been supplied to this appellant. Thus, the structure is very small and could not be regularized. But that has not been considered by the learned special officer building. So the appellant has prayed that the order passed by the special officer may be set aside. Points for decision: whether the impugned order passed by the special officer building suffers from any illegality or irregularity. Both the points are taken up together for discussion as they are closely related to each other and also by the privity of discussion. Before coming into the matter, it is the place to mention that one Jamila Khatun has filed a petition before the tribunal praying inclusion of herself and others as a party to this appeal. The petition has not been moved by the learned advocate of Jamila Khatun, and on being mentioned in this tribunal, subsequently he moved the petition on 10/4/23, and considering the circumstance, the petition has been allowed. It reveals from the case record that this appeal was filed on 24th June 2022, but the impugned order passed on 18/5/22 by the learned special officer building as per direction of the Honorable Court Calcutta, passed in MAT for disposal of the matter. So the matter of limitation has become redundant, and thus the appeal has been taken up for final hearing. Learned advocate for the appellant has submitted that this appellant has a leaseholder of the disputed premises. But now, my lord, when the appeal was heard, he brought out that's why, my lord, I needed to file the supplementary affidavit. My lord, he brought out a case that I have not done. My predecessor, he has produced, my lord, two unregistered lease, my lord. He has tried to, my lord, shift the burden upon his predecessor, as if the lesser has made the same. My lord, first of all, my lord, the lease is unregistered, and at no point of time, my lord, this story has been stated either when the writ petition was filed originally by us before this honorable court or before the special officer building. But for the first time, my lord, this story has been made out, and my lord, they has by making out this story, he has tried to escape from the liability by saying that it has been made by my predecessor, and his predecessor is responsible. I am not responsible. My lord, your lordship is knows that, but here, my lord, the notice has been issued in the concerned premises. My lord, writ petition has been contested, which has been filed by me, contested by that particular person. In the special officer, before the special officer contested that particular person, an appeal has been preferred by that particular person. Thereafter, writ petition filed by that particular person, and my lord, against that, my lord, appeal before the division by particular person. But while the building tribunal appeal was heard before the building tribunal, a new case has been framed and formulated, and this release document was for the first time produced, and by saying by unregistered deed, my lord, it is backdated or something, my lord, and by saying tried to shift the burden, my lord, the person responsible to be answer, my lord. Here, my lord, we have also made that person party also, my lord. The alleged predecessor has also been made a party, my lord. My lord, let him produce the function plan or building plan. Question is whether plan is there or not. My lord, kindly see them, how the order has been, my lord, passed, my lord, kindly see. Learned advocate for the appellant has submitted that this appellant has a leasehold of the disputed premises. He has not constructed the structure at all. The structure itself has been recorded by the Kolkata Municipal Corporation in IB book. My lord, we have, that's why, my lord, we have produced the, my lord, supplementary affidavit. IB book does not contain any structure, my lord. He has submitted that the appellant has leasehold for the said structure and the appellant has been occupying the structure legally. He is not the person responsible. He has submitted further, well, he has submitted further that the special officer building has not served notices under section 400 of the Calcutta Municipal Corporation Act against the original owner of the property, and as such, the proceeding has become infructuous. The appellant has no way for any right to carry out the order of demolition. Changing the course of argument, learned advocate has further submitted that there are godowns in the same premises. The godown occupied by the appellant is a very small one, but another godown has been constructed illegally by Jamila Khatun and others, is a very big one and dangerous in nature. He has submitted further the same report. The engineer of the Calcutta Municipal Corporation has reported before the Kolkata Municipal Authority about both the structure, but it is very much curious enough that no proceeding has been initiated against the added respondent Jamila Khatun and others. He has submitted that the added respondent have been occupying the very big illegal structure, but there is no whisper of it from the corner of the special officer building against such illegal act done by the. He has further submitted that the proceeding is totally illegal and has been initiated in wrong basis. The added respondent Jamila Khatun and others shall be served with the notice under section 401. He has submitted that for such irregular proceeding, under no circumstance this appellant can be suffered. He has prayed that the impugn order passed by the land may be set aside. My lord, here, my lord, the appellant, that means the original, my lord, original respondent in my petition, he is, my lord, seeking relief. My lord, on the garb of, my lord, the lesser, my lord. Learned advocate for the KMC has submitted that the structure is illegal and should be demolished. He has, my lord, corporation has stated the structure is illegal and he supported the order passed by the special officer. Well, in spite of that, my lord, can you see, learned advocate on appearing on behalf of Jamila Khatun and others has submitted that the structure in dispute is illegal and rightly ordered for demolition. He has submitted that the matter was referred before the Honorable High Court, Calcutta, and in view of the direction of the High Court, Calcutta, the proceeding has been initiated and impugn order has been passed. So this appeal is not tenable at law. Peruse the impugn order passed by the learned special officer building, the case record of the SO building, the memo of appeal, and the other documents lying with the case record. It reveals from the impugn order passed by the learned special officer building that he has initiated the proceeding as per the direction of the Honorable High Court, Calcutta, passed in WPA number without being initiated any demolition case. My lord, this is incorrect, my lord. In proper form, only notice has been served upon the appellant Ram Saram Agrohari. It reveals from the copy of the order of the Honorable High Court filed by the Jamila Khatun that the Honorable High Court, Calcutta, was directed to start a proceeding for illegal construction against the respondent of the writ petition. It becomes unknown that why Special Officer Building has not started proper demolition case in view of the order of the High Court, Calcutta, because there was no mention of any D case in the certified copy of the impugn order. A clear study of the case record goes to show that there are presence of more than one structure in the disputed premises. It reveals the materials on the case record that there is a violation of the building rules in all structures. It is the claim of the appellant respondent is that appellant person responsible is that he has a lease of the property in dispute. The original owner has not been served with the notice under 401 of the Calcutta Municipal Corporation Act. Well, original owner did not prefer any appeal nor come forward. Here also we have made him party forward to place his before the special officer building. The appellant has filed a lease deed executed by Arshad Hussain and others in favor of this appellant in respect of structure which has been directed for demolition. The documents lying in the case record of that goes to show that there are two structures. One is small in nature and other is very big in nature on the same premises as detected by the engineer of the Calcutta Municipal Corporation. There is no explanation in the order of the assessor that why no notice under 401 of the Kolkata Municipal Corporation has been served upon the added respondent. And we have no grievance for the same. And others, we have got the notice. We have who has claimed themselves to be the owner of the structure. It reveals from the case record and as well as from the documents filed by that respondent Jamila Khatun and others that the said Jamila Khatun has filed title suit number in the route. Jamila Khatun and others have been claiming their right title and the applicant, the tribunal has got no jurisdiction whatsoever. Kindly, it's a mess, it become a mess, my lord. It has become a mess. My lord, thereafter, my lord, to give a merit of the civil nature pending by between parties. Thereafter, my lord, the next page I am shifting. My lord. If there be any illegal construction, then the original owner of the property, including the added respondent who have been claiming their right, title, and interest in another part of the property, should be served with notice. My lord, for coming to conclusion, the conclusive decision about the structure, and any demolition order is required to be passed, that should be passed against the person responsible who have constructed the same, and the lease and leased but the same to any other person. Therefore, it is crystal clear from the document filed by both the parties that the actual person responsible have not been made parties to the proceeding in dispute. It goes to show from the case of that in the IB book there is a very existence of the property and taxes have been collected from the owner property. Therefore, for these irregularities and misjoinder of parties, the impugn order passed by the learned special officer cannot be taken as a sacrosanct according to this impugn order passed at the this is the order, my lord. By it, kindly see that the alleged lessor has not, my lord, challenged the order passed by the special officer, either by preparing any appeal or by filing any writ petition, and they have also been made party here, my lord. That it is an undisputed fact, my lord, that the structure has been made unauthorizedly. Even today, my lord, no sanction plan is there, my lord. So, my lord, this order my lord, does not reflect, my lord, the compliance of the direction of the appellate court as well as, my lord, the writ court. My lord, it is amply clear that unauthorized construction has been allowed to be retained. And, my lord, it is also astonishing that although this order has been passed by the building tribunal, asking the, my lord, special officer to, my lord, take fresh step, and that order has been passed, my lord. My lord, kindly see, this order has been passed long back, my lord. We are also not getting any notice of taking any fresh step as well. So, my lord, this unauthorized act is allowed to stand by some, my lord, tricks which may not be, my lord, allowed to be remain, my lord. So, my lord, order for demolition may be passed, asking directing the corporation, my lord, to take immediate steps for removal of all illegal and unauthorized construction.
Yes. We'll come back after 5 minutes.
petitioner, Lord, I want to add little more. For the bit, only just 5 minutes.
Yeah, there in this matter, sir.
Yes, for the petitioner.
Yes.
Just your lordship kindly see the order of the tribunal and page 87.
Page
87.
আমাদের 18 তে কত আছে?
What order the tribunal is setting aside. Your lordship kindly see that the impugned order dated 18/5 passed by the learned SO building in respect of the premises number such and such in view of the direction of the Honorable High Court. That is not the show order of the special officer building.
Yeah, but your friend is,
Yes, that
there's only one petitioner here.
what?
Are you leading him or he is leading?
I want to add little more.
No, but what is this practice?
Little more.
You tell him whatever he has to.
Given permission.
Let them say. দর্শক কেন করে লাভ পরে হবে না রিপ্লাই করবে বলতে
You reply after that, yes.
Lord, I appear on behalf of the Kolkata Municipal Corporation. Lord, my first limp of submission whether the writ petition is maintainable or not. Lord, this order passed, Lord, the petitioner challenged the order passed by the municipal tribunal. This is, my Lord, under section 400, subsection 3 of the Kolkata Municipal Corporation Act. Lord, the final order passed by the municipal building tribunal, it's a quasi-judicial authority. My humble submission, the writ petition should not be maintainable. Because of, my Lord, this is a quasi-judicial authority. Subject to correction, my Lord, there is a judgment. This, my Lord, that's why, my Lord, I need to some, my Lord.
So where will the appeal go?
My Lord.
Where is the provision for appeal?
My Lord, appeal, my Lord, appeal under section 400, subsection 3.
I am saying where will the appeal from the tribunal go?
Lord, I could not follow, Lord.
You are saying it is not maintainable.
Lord, no, writ petition is not maintainable because of.
That's what I'm saying. Where will the appeal? Where will the appeal lie from this order?
Lord,
according to you.
But under Article 227. It is
under 227.
My Lord, my understanding of subject to correction, my Lord, there is a difference between, my Lord, there is a judgment of this honorable court. I need to some time because of find out that there is a larger bench of this honorable court, and it has been decided. The tribunal order under the statutory tribunal order has to be challenged by way of 226, and the constitutional the order passed by the constitutional tribunal order to be challenged before this honorable court, before the division bench. There is a slight difference, but that's why, I need to some more the time so I can find out that judgment. First, my Lord, I
got that judgment now.
My Lord,
if you are making that argument, you should have come prepared.
My Lord, because of some more time, because, my Lord, this, my Lord, judgment is very important. If I am not fine, my Lord, then, my Lord, Lordship will proceed. But, my Lord, my for my my Lord, for the work of my knowledge of that, my Lord, I need to some. And apart from that, my Lord, if Lordship has, my Lord, not, my Lord, consider the in respect of, my Lord, maintainability. No, other point, my Lord, I can argue that. But before that, my Lord, it is my
make the complete argument. I can't hear you in bits and starts.
Because, my Lord, kindly give some more time. If I am not, my Lord, satisfied before Lordship in respect of maintainability, then Lordship can proceed. But before that, my Lord, I have to
take down.
My Lord, I say that, my Lord, this application has been served at least 2 years back. He filed opposition, my Lord. The
opposition filed?
Yes, you filed. My Lord, report has been given. Opposition has been filed by the corporation.
Where have you taken the ground of maintainability in the opposition?
I don't know.
In the opposition filed by
affidavit on behalf of
affidavit in opposition filed by the corporation.
Affidavit filed by the corporation, my Lord. This. Hello, kindly see, this has been filed as per back on, my lord. My lord, this has been, my lord, affirmed on April 2024.
I'm sorry, my lord.
2024. And corporation is also supporting that unauthorized construction has been made, and they have, my lord, approached, they have stated before the tribunal that the building should be demolished. This is the positive case of the corporation. They cannot deviate from the same. It will reflect from the, my lord, order of the special officer, order of the building tribunal, my lord. The corporation submitted before the tribunal that the construction should be demolished. Look, kindly see this portion of the order. This is their submission before the tribunal, my lord. Down.
পুরোটা পুরো উঠতে পারিনি।
My lord, kindly see page 83, my lord. Page 83 of the, my lord, writ petition, my lord, from which the submission of the tribunal corporation will appear, my lord. My lord, kindly see learned advocate for the page 83. I'm, my lord, citing. Learned advocate for the KMC has submitted that the structure is illegal and should be demolished. He has supported the order passed by the special officer building. It is the case of the corporation.
আরে ওসব আমি জানি, এগুলো দেখিলে আপনি আগে আমি মেইনটেইনেবিলিটি পয়েন্ট যদি না শুনতে যাই আমি।
It is their positive case that the unauthorized construction should be demolished.
You're yourself saying it.
Who is that?
Kindly see.
A learned advocate for the KMC.
Now, this order passed by the tribunal, my lord. The tribunal is the independent authority, my lord. After considering the materials and, my lord, the tribunal has, my lord, the considering his, my lord, judicial mind exercise and, my lord, passed an order. My lord, my lord, the page 83 paragraph. This is the submission. It has been recorded. My lord, kindly see the finding of the tribunal, my lord.
Yes.
My lord, page 84. Page 84. My lord, start from, my lord. Consider it revealed from the impugned order passed by the learned SOB that he has initiate the proceeding as the direction of the Honorable High Court Calcutta passed WPA number 15791 of 2020 without being initiated any demolition case in proper form. Only notice has been served upon the appellant Ram Saran Aghori Sau. It reveals from the copy of the order of the Honorable High Court Calcutta WPA number such and such filed by Jamila Khatun and others that the Honorable High Court Calcutta was directed to start a proceeding for illegal construction against the respondents of the writ petition. It become unknown that why the learned SOB has not started proper demolition case in view of the order passed by the Honorable High Court Calcutta, because there is no mention of any D case, that means demolition case, in the certified copy of the impugned order passed by the learned SOB building in respect of the added respondents. But this case mapped in the part and parcel of the demolition case. Otherwise, my lord, when the execution of the demolition, my lord, this case map has to be followed and has to be demolished. Apart from that, without this case map, the demolition order communicated that itself, my lord, bad in law. Then, my lord, a clear study of the case recorded of the learned SOB building goes to show that their presence of more than one structure in the disputed premises. It reveals from the materials on the case recorded of the learned SOB building that there is a violation of the building rules of the Kolkata Municipal Corporation in all structure constructed by the owner of the property. It's very important, my lord, the owner of the property. It is a claim of the appellant, person responsible is that he has a lessee of the property in dispute. The original owner has not been served with the notice under section 400 subsection 1 of the Kolkata Municipal Corporation Act. Come forward to place his case before the learned SOB, Special Officer Building. The appellant has filed a lease deed executed by Arshad Hossain and others in favor of this appeal and in respect of the same structure which has been directed to demolition by the learned Special Officer Building. The documents lying in the case recorded of the learned Special Officer Building goes to show that there are two structures. One is small in nature and other is very big in nature on the same premises as directed by the engineer of the Kolkata Municipal Corporation. There is no explanation in order of the learned SOB that why no notice under section 400 subsection 1 of the Kolkata Municipal Corporation Act has been served upon the added respondents, Jamila Khatun and others, who has claimed themselves to be owner of the property in these regards. But that means the petitioner has claimed, my lord, they are owner of the property.
What about
It
the
reveals-
second? Wait a minute. There are two
My-
directions which have been passed by the tribunal.
My lord, subject to, yes.
There are two directions which have been passed by the tribunal. One direction is that they have set aside the order which has been passed by the
A
SOB.
Special Officer Building.
The second is for you to initiate proceedings under section 401. What have you done?
My lord, my lord, I have to take instruction. The fresh proceeding has been.
Why you have not done that?
My lord, it is my my lord, fault. I admit that it is my fault because it's a long vacation, my lord. I could not, my lord, take it. My lord, kindly give a, my lord, 2 days time. I shall, my lord, take instruction. Only the after, my lord, after.
You'll have it next week.
My lord, next week.
Next week.
Yes,
This
yes.
is an order which has been passed in 23.
Yes, yes, my lord, I have to take instruction whether
Take
the.
instruction. I'm sure they must have initiated proceedings.
Yes, my lord.
Where is the demolition order which has been passed?
Yes, yes, my lord, I shall take instruction. Proper.
You have to pass a demolition order. You have
definitely,
to
my lord.
initiate proceedings
Yes, my lord.
in accordance with law.
Yes, my lord.
You have to comply with
Yes,
directions.
yes, yes, my lord. Otherwise, my lord, they will face the consequence.
Let them come up with the instructions. Sir.
Yes, my
Learned counsel for the respondent corporation seeks and is granted 1 week time to seek instruction regarding the directions regarding the direction passed in the BT appeal number 113 of 2022, whereby the corporation, the learned SO building, whereby they were directed to issue notice under section 401 of the Calcutta Municipal Corporation Act to all the concerned parties to initiate proceedings. To initiate proceeding under section 401. Let this matter be listed after. When do you want?
Next week.
Next week?
Yes.
Next Wednesday.
Yes.
Next Wednesday.
Wednesday. But I am appearing for the state in this matter.
What Aldo? Oh, sorry. The next Wednesday is a holiday. Next to next Wednesday.
Wednesday week.
Next to next.
Wednesday.
12th. इसमें वो डाल देना आप कमाल. The affidavit in reply is taken on record.
Yes.
Affidavit in reply filed by the petitioner is taken on record. Affidavit of service as well as affidavit in reply filed by the petitioner to the affidavit in opposition of the KMC is taken on.
My lord, 18, my lord, I am appearing for the petitioner, my lord. Kindly adjourn it, my lord, for 2 weeks because, my lord, advocate on record, she has not come to court, my lord. She is ill, my lord. During the vacation, my lord, her operated, my lord, and then after operation, now she is better, my lord. On that count, kindly 2 weeks adjournment.
Who's not well?
Yes, my lord.
Who's not well? Who's unwell?
Advocate on record, Mr. Ananda Adhikari.
Learned counsel for the.
And my lord, another, my lord, and this 4 writ application, kindly These 4 writ application and this is interpretation analogous matter, my lord. We had analogous, my lord.
Not able to follow you.
Another 4 writ application, my lord. I am for the addition of party. That writ application appeared before your lordship list on September. Thereafter, my lord, that matter assigned before the another bench up to 26th of September. Not now. Till date, my lord, your lordship at the jurisdiction, my lord. These 4 matter and this matter, my lord, is analogous matter, my lord. Recruitment scam matter, my lord, all the same matter, my lord. Kindly matter be had along with this matter.
Oh, we'll see that at that point of time. Just take down learned counsel of the petitioner states that advocate on record in the presented petition is indisposed. He prays for a short adjournment. He prays for 2 weeks adjournment. Let this matter be listed after 4 weeks.
Your Lordship, respondent number 6 may be granted leave to file exception to the report filed by the state. State has filed a report. We have received it after the matter was taken up on next.
You are?
Saturday. I'm for respondent number 6, Your Lordship. We are seeking leave to file exception to the report filed by the state, Your Lordship.
No. State is respondent number 2.
Yes, ma'am.
You're for respondent number 2.
The state.
State.
Report has already been filed and exception
Last time and same as that.
and exception has been filed by the petitioner.
Yeah, respondents don't file exception.
Your Lordship, in this matter we have
my lord, to file the exception, my lord.
Sorry?
I am for the petitioner, my lord. I have already filed the exception, my lord.
Your Lordship, in this matter it is required, Your Lordship. What has happened? The DLB has challenged the, I'm for the petition, the particular employee in respect of whose appointment the entire issue has been culminated, Your Lordship. The matter went up to Supreme Court. DLB has filed appeal, and thereafter SLP has been filed. My appointment has been upheld by the Supreme Court, Your Lordship.
You'll see that.
All right, sure.
I'm grateful to you.
Those documents are not there in the report. Your Lordship. That is why I was mentioning.
We'll see that.
All right, sure.
Yes.
Lord, on 15th July 25, my lord directed the corporation to file an affidavit. Lord, today they have served us not few minutes back. So from 15th July, we got it in October. Lord, give us a week's time at least to come back with a report.
But I'm appealing for the private respondent, my lord. We have also received the copy today, my lord.
Learned counsel for the petitioner.
But Lord, the main issue that we have raised in the writ petition that has not been addressed in the affidavit. Whether, my lord, in an undivided property, a plan could be sanctioned or not. That has not been addressed by the corporation in the affidavit. That was your lordship's query, my lord, when the matter was being heard. But I find nothing reflects from the affidavit. I'll deal with the affidavit, my lord.
Affidavit is on record.
Lord, may I file the affidavit?
Copy though.
7ই নভেম্বর আমি নেই 7 আর 11 নেই আজ কত
Affidavit in opposition on behalf of respondent number 227 is taken on record. Learned counsel for the petitioner seeks and is granted 2 weeks time to file his reply to the opposition of respondent.
But only one thing, my lord, I am for the private respondent. Kindly permit me to file an opposition, my lord.
ওদের ফাইল অপোজিশন করেছে তো ওরা
Madam, may I just permitted to file an opposition, my lord?
Just a minute.
Private respondent
I'm
has
sorry,
already
I'm sorry.
filed his opposition, my lord, against the writ petition. They have already filed their opposition.
They have
But
filed
Mr.
their
Mukherjee is
opposition,
seeking-
Mr.
They have
My
filed
lord,
their-
against this, my lord, if required anything, my lord, if required anything. Your lordship permitted the petitioner to file exception, if anything required, my lord.
I'm
Lord, Mr. Mukherjee is perhaps against the opposition of the corporation. He wants to file a reply. I am the petitioner. Why would he file a reply?
You don't
But
need to
he
file
has-
anything,
Yes.
Mr. Mukherjee.
Lord, 2 weeks ends on 10th. Perhaps
10th of?
10th of November. 2 weeks ends on 10th of November.
When do you want 2 weeks?
10th of November. 10th of,
But kindly fix in after 15th, my lord. Any day, my lord.
very well. Then 17th. 17th is the third week.
18th, 19th November.
19th November.
Grateful, lordship.
20 I appear for the petition, my lord. There was direction upon the respondent to file an opposition. My lord, if my lord kindly sees.
Well, I am filing my opposition. I am filing two separate oppositions, my lord, on behalf of the respondent number 2 as well as 3 and 4, my lord.
Yes.
My lord, we will write to use a reply to this. You have just received.
Affidavit in opposition. On behalf of respondent number 3 and 4 is taken on record. Affidavit in opposition on behalf of respondent number 2 is taken on record. Learned counsel for the petitioner seeks and is granted liberty to file his reply to the affidavit in opposition filed by respondent number 2 as well as the reply to the affidavit in opposition filed by respondent number 3 and 4. Let this matter be listed for hearing on date in December or in January. Okay. No urgency in this.
My lord, keeps it in any time in November. After 15th, no issues.
Why in November? What is the urgency? Any urgency? Let it go in January.
We are not taking any coercive steps against him.
Very well, my lord.
January.
Submitting.
List date देने का जरूरत ही नहीं है. List after 6 whatever 8 weeks. Weeks will take it to list after 10 weeks.
Yes.
I'm for the petition, Lord.
21. 21, I on behalf of the state, madam, I am filing the opposition. Affidavit in opposition.
Lordship, in respect of 21, I am filing the affidavit in reply. Lordship.
And for the municipality, we have filed our opposition, Lord.
Going to file your reply to this affidavit in opposition?
Lordship, reply to the respondent number 2 and 3, Lordship.
That's the corporation.
Corporation, Lordship. But we didn't get.
Stated.
Today,
Affidavit in opposition on behalf of respondent number 1 to 5 is taken on record. Affidavit in reply to the affidavit in opposition of respondent number 2 to 3 is taken on record. Full stop. Learned counsel for the petitioner seeks and is granted 2 weeks time to 2 weeks, 3 weeks.
Lordship, 2 weeks.
2 weeks time to file his reply to the affidavit in opposition of respondent number 1 to 5. 1 and 5. 1 and 5. List after. Mr. Banerjee, when do you want?
Lordship, after 15 on any day, Lordship.
Any urgency? What is that?
Lordship, this matter is pending since long and
The 24 matter.
24.
26th November.
Lordship, item number 22.
Same. Same.
But,
Connected. Lord, there are two writ petitions. One is we have passed a demolition order. One is for implementation of the demolition order. The other matter is not challenging the demolition order. They want regularization. They have deposited the money. So both may be taken up together.
So these are item 22, 23.
22, 21, 22.
All right. List along with उसमें कर देना second वाले में list along with some. Same. Okay.
23, my lord, it's a different matter, my lord. I am paying for a not today and not tomorrow. Some difficulties with that.
My lord,
Not today.
in this matter, my lord, corporation has my lord, submitted report stating that no unauthorized construction has been made. My lord, I think, my lord, your lordship kindly see the report.
I am filing my reply and
Yes,
kindly
yes,
take up
this
day
is-
after tomorrow, my lord.
It is totally a private dispute, my lord, for my lord, personal, my lord, grievance against the
You
private.
are appearing for the corporation.
No,
Private response.
I am for the private respondent, and corporation has submitted report in terms of the order passed by your lordship. And my lord, your lordship may kindly take note of the same, my lord. For the private-
Who's there for the corporation Rajpur Sonarpur
It is municipality, it is not
Not appearing
corporation,
today.
it is a municipality.
municipality?
Yes.
All right. What are you filing?
My reply to the affidavit by the municipality.
Affidavit in reply. Petitioner's affidavit in reply to the affidavit in opposition filed by respondent number 2, 4 and 5 is taken. He's here.
Yes.
Is taken on record. Full stop.
Report দিয়েছেন
Petitioner prays for a. Let this matter be listed on. When do you want?
Day after
So I am
tomorrow.
for the municipal
Day after
lordship.
tomorrow.
report, my lord.
इससे पहले कर देना affidavit in opposition on behalf of respondent number 2, 4 and 5 is taken on record. उसके बाद कर देना. Petitioner seeks. Petitioner files his affidavit in reply. Files his affidavit in reply to the affidavit in opposition of 2, 4, 5. Let this matter be listed on. Then it's for hearing.
29th, my lord.
No.
When do you want hearing? 29th.
29th.
29.
Short point, my lord.
29th is Friday or what?
And
Today is 27th, Wednesday.
27th of this
Today is 27th of October.
Thursday.
29th is not Wednesday.
ছুটি আছে না?
না, না। 30 তারিখ ছুটি তো। 30th is a holiday. 29th.
All right, 29th.
Diploma.
Yes.
My lord, 24 and 25, my lord.
24, 25.
My lord, on the 1st of July, my lord, your lordship.
I'm for Kolkata Municipal Corporation led by Mr. Shontipan Banerjee.
My lord, I'm appearing
Appearing
for
for
the
not today.
I'm appearing for the private response. On 1st of July, your lordship passed an order, my lord, whereby the corporation was directed to inspect my premises and file a report within a period of 4 weeks, and exception, if any, be filed within 1 week thereafter. Now, my lord, till date, that report has not been circulated. So, my lord, unless and until that report is circulated, my lord, I'm not in a position to take all my points in my opposition to their writ petition. So, my lord, that direction may be given upon the corporation to file the report within a week's time, my lord.
Where's the report? What are your instructions?
I have no instruction, Lordship. I'm praying for not today.
Not today.
Good, my lord.
Your Lordship, this was my application. Mr. Shuddha Sattva Banerjee was leading me in this matter. On the last occasion, we had given our written notes of submissions. The short point that was that subsumed the matrix of this matter was, Your Lordship, whether the permission of the court would be required for development of a private Devottar estate. We cited judgments to the effect that it is not needed. One judgment of a bench presided by Justice Joymalla Bakshi, of which Your Lordship was also a part. Your Lordship, subsequently, Your Lordship, my learned senior had showcased around 63 judgments. We've dealt with that in our written notes. Most of them with the greatest of respect. It applies to the Estate Acquisition Act, and even otherwise it's not applicable. Our written notes of arguments are ready, Your Lordship.
May I file my report?
But
Lordship,
I,
you've
as
not
I
been served a
submitted,
copy.
আমি একটা কপি তোকে আগে দিয়েছিলাম, এটা থেকে জাজমেন্ট কত করে ছেড়ে দিয়েছি?
Your Lordship, now, Your Lordship, now some judgments have been let go by.
No, I have referred those judgments, some judgments I have deleted, my lord, as I submitted the spiral binding, my lord, remember, my lord, return me. I have, my lord, shortened those judgments, my lord, I have given some judgments. The text of the written notes, my lord, are there, and all the judgments are reported judgments. I believe it is there. If still then my learned friend insists, my lord, I'm handing over again.
Your Lordship, because
No
if some
problem
new
with that.
judgment has been cited, we ought to be given an opportunity to.
No new judgments, no new judgments.
Because Your Lordship, if I can just showcase from my written notes of arguments, Your Lordship, if I may just hand over a copy to Your Lordship. Your Lordship, I'll just hand over a copy. Your Lordship will kindly see. Lordship will kindly take up page number 9 onwards. Those are the decisions relied by the respondent. Your Lordship, factually and even on the points of law, Your Lordship will just on a cursory glance appreciate that this has no relevance to the dispute that is sought to be agitated. The offending document, Your Lordship, at page number 117 of the writ petition, and Your Lordship, we have cited Mohinder Singh Gill also formally in this written notes. Your Lordship, the KMC, with the greatest of respect, cannot traverse beyond the limited circumspect in which the offending document has been issued. Only 2 points were raised over there. Your Lordship will just kindly take up the offending document once and then look at the circumspect in which they have traversed. Your Lordship will just kindly take up page 117 once.
Yes.
Two aspects over here, Your Lordship. Number one, that the order of the learned court is required. For that, Your Lordship, we have not only supplanted judgments before Your Lordship, a document issued by the government of West Bengal had also been proffered to Your Lordship to the extent that this was not required. Your Lordship. Secondly, with respect to a case pending before the learned Shialda court, Your Lordship, this case has been withdrawn. So, Your Lordship, that case is, this aspect is no longer res integra, Your Lordship. And Your Lordship, the question of title also, because in our averments in the writ petition, we have proffered to Your Lordship as to how there is the financial condition in which the trust is in today. Your Lordship, it's in a deplorable state of affairs. We are not being able to manage the basic necessities that are required for preferring the daily Shebo Puja, Your Lordship. So, Your Lordship, in light of that, and Your Lordship, it's not that we are neglecting the deity. My learned senior had also addressed Your Lordship, and he had placed very extensively both the versions, both the Orpon Namas, Your Lordship, the original Orpon Nama and the rectification, Your Lordship. Your Lordship, the power of the Shebayats to carry out such construction when it is in the need of the deity, Your Lordship, that permission has been explicitly accorded in the original Orpon Nama. Your Lordship, that, Your Lordship, my learned friend has disputed, but he's not been able to showcase from a perusal of the Orpon Nama as to how such fact can be proved to the contrary. Your Lordship, even otherwise, there was another dispute, and rightly, Your Lordship, a query had fallen from Your Lordship with respect to the Shebayats who had signed and affirmed this writ petition and also applied for permission, and a power of attorney holder was appointed in this regard. Your Lordship, those documents have also been proffered to Your Lordship. In fact, Your Lordship will appreciate that there were originally 3 Shebayats. Your Lordship, only one of them was issueless. One had passed away. His son has been incorporated because by dint of the succession, Your Lordship, by dint of the Orpon Nama, it is the living male heirs of the Shebayat who has passed away who will come into the office of Shebayatship. So, Your Lordship, this office of Shebayatship is heritable. So, Your Lordship, out of 3, the third one has passed heirless. Your Lordship, the other 2, one is living and the other one's son, they have been brought on record, Your Lordship. So, Your Lordship, beyond this, beyond the offending document, Your Lordship, with the greatest of respect, I don't see any reason how my learned senior can come and object with respect to any aspect, with respect to the conscience or otherwise, Your Lordship, because the law which has been settled, Your Lordship, is that, Your Lordship, the learned permission of the court is not required in this regard. And, Your Lordship, there is a specific exclusion in section 1 of the Trusts Act, Your Lordship. That also we have placed, Your Lordship, with respect to a private Devottar estate, Your Lordship. This is not a public or a charitable Devottar, Your Lordship. So it is not subsumed under the scope of the Religious and Charitable Trusts Act of 1920 or the Trusts Act of 1882. In fact, Your Lordship, section 1 specifically excludes its application in such regard. You like? Right. Lordship, now.
For my lord's recapitulation, my lord may remember that I have shown, my lord, that there are 2 Orpon Nama. One is allegedly, my lord, rectified Orpon Nama. That rectified Orpon Nama specifically speaks of that in the original Orponnama, there was no express permission for such development or sale or otherwise, or encumbered the property. Now the question that necessarily follows, my lord, whether a rectification of Orponnama can be done even by the original my lord, persons who, my lord, prepared the Orponnama. Because once it is vested to the deity, the original owners before such Orponnama are nobody. The Sebayas appointed, they will just manage. And there is no such permission. Even in the original Orponnama, my lord, will find that there is a specific provision. Because I'm saying this, that the financial condition, that specifically speaks of that in case there is financial crunch or any difficulty, the Sebayas will pay it from their own pocket and subsequently will recover. This is one aspect of the matter. The other aspect, from the schedule of the property in the Orponnama, my lord, will find there are number of huts and shops let out to the various persons. And my lord, it is their contention that no one is paying, no one is doing anything. My lord, despite the power, it is not known why no steps were taken against them. These are the factors, my lord. The plea taken.
Steps were taken against them means?
Yes.
No steps taken against them means? That
No
they should
steps
be
taken against for realization or, my lord, appropriate proceeding for, my lord, eviction.
But how does that concern you?
No, I'm saying it is in respect of the plea that there is no provision, they are in financial crunch. For to this limited aspect only. What they are saying that for that purpose it is there. But I have also,
Even if you are not looking into the financial aspect,
yes.
you are only
Now come, my lord. Now the very important thing is, my lord, that my lord will find that one constituted attorney of another Sebai, Abha Sinha, or like this, my lord, still lady. She was there, my lord. She was appointed as constituted attorney on behalf of one of the Sebais. Now she, my lord, further delegates power to the present petitioner who has affirmed. And I have shown, my lord, from page 101, 2, 3, always, my lord. At the top, my lord, says that constituted attorney of, my lord, Janardhan Jew. And, my lord, at the bottom, only 2 persons' name have been given. Now the question would be, my lord, whether such a power can be given.
Lord, I'll just end this because
Just a minute.
one
Just
person
a
has died.
Just a minute. Just a minute. Be that as it may. One person died issueless. No. Bolo na issueless to. ঠিক আছে. 2 persons are there. Now, my lord, question would be whether the principle of delegatus non-potest delegator is hit by this. A person who has been delegated with some power can further be delegated to a third person. You will also find from the page, affidavit page and the petition as well. All these things are there. And the most vital and important thing is, my lord, I have submitted that in all laws prevailing in the state, my lord, the deity is all along considered as a minor, perpetual minor. In a for a perpetual minor, my lord, who will administer? Who will look into this? Whether this is there or not. For this and for this reason, my lord, there is a division bench judgment of this honorable court. I have shown, my lord, that for that purpose, my lord, a permission from the district judge has to be obtained. And the judgments referred, my lord, in which my lord was party, that judgment, my lord, subject to correction, deals with, my lord, Indian Trust Act. There it has been held that no permission is required. But Orponnama is basically and qualitatively different from that of trust. Whether, my lord, the Sebaites will be there or died issueless or otherwise, then, my lord, it can be administered, managed, and controlled by the court, my lord, a competent civil court, my lord, by appointment.
you come after lunch. We'll hear you.
If he finishes, I'll take 30 more seconds, my lord. I will not trouble you, lordship.
Come after lunch.
Yes, Parikh.
We will hear him more.
No.
Whatever,
Nothing.
at least you give the clarification.
I have given,
Whatever
my lord, and what I am giving the written notes, my
written
lord.
notes, whatever are there, the points, you can
No,
just
these
clarify.
are the points, my lord, for my lord's recapitulation. I have submitted everything. I have jotted down in a very, my lord, short manner. That's why I am.
Come back after lunch.
Well, I don't know whether after lunch there will be court or not.
Why?
Because of this reason, I just heard it. I have not.
We are back after lunch. I am back after lunch.
I will also be back after lunch.
3:15 we have to assemble for the.
Very well.
The written notes. It would be greater if I hand over a copy to my lord. At page 3 onwards, my lord. Before that, your lords will kindly see, I have also stated that pursuant to this honorable court's direction, my lord, a report was filed, and there, my lord, it has been stated why it is not there. This report is on record. In that affidavit, my lord, the writ petitioners have also used their reply. Now, my lord, the points from page 3 onwards, my lord, will find that the writ petition is not maintainable for the following reasons I have quoted, I have stated, my lord, supported by the judgments. Well, page 3 onwards, my lord, it has been stated, and there, my lord, I have contended that after the property was dedicated, my lord, they are divested of all rights. So subsequently, they cannot change the writings of the Orponnama because they do not have any power. They lost all their right. So the alleged rectification of Orponnama in a subsequent date and banking upon that, my lord, claiming building sanction plan, my lord, is not at all available, and the said rectified Orponnama is void ab initio. Then, my lord, I have stated, I have given the judgments also, my lord, and I have also stated, my lord, that the deity is a perpetual minor, and as such, it cannot maintain a writ petition of its own. I have stated that, my lord, and I have relied upon a judgment, my lord, I have referred to, and I have given the copy. Next, my lord, in Roman 5, page 8, my lord, I have given the details, my lord, what are the properties and how it is there. Because, my lord, your lordship will have to appreciate the contentions raised in the writ petition. And, my lord, your lordship will consider the conduct, whether it is true or for the purpose of grant of sanction, some statement which has been made is beyond the scope. That's why, my lord, I have stated, my lord, what is there. Next, my lord, I have also submitted, your lordship will kindly come. The rectification of Orponnama was done by whom? And the original Orponnama was done by whom? At page 7, my lord, the rectification I have stated by one Satish Chandra Sinha, son of late Bimal Chandra Sinha, executor of late Bimal Chandra Sinha, Adhish Chandra Sinha, son of late Amaresh Chandra Sinha, and Vikas Chandra Sinha, sole legatee of late Vrindavan Chandra Sinha, by constituted attorney of one Shamapada Sinha, son of late Durgadas Sinha, and one Abha Sinha, constituted attorney of Adhish Sinha. But there I am on. Your lords will kindly appreciate that the principles, the doctrine, my lord, the delegatus non potest delegare, whether it would be applicable or not for this purpose. If it is not there, then my lord, the vokalatnama on that string, even if it is given, that will also become bad. And if my lord kindly turns to the writ petition, my lord will find who has affirmed the affidavit. He is another constituted attorney, my lord, appointed by these persons.
That is one Mr. Bed.
Yes, Beige. Whether he can do this or not. Whether this can be entertained at all or not. Now, my lord, the question would be here, the judgment which I have said, my lord, in respect of perpetual minor, that is 2016 SEC online, my lord, it's a division bench judgment. And my lord will find that there it has been clearly stated that a permission from the competent civil court has to be obtained because the deity is a perpetual minor. In my In paragraph 8, my lord, I have stated that the signed by the petition and the reply has been signed by one Vinod Kumar Baid, allegedly claiming himself to be the constituted attorney of the petitioner. The deity is the owner of the property. The Sebais are agent or manager of the deity. Sebais have put their signature through constituted attorney. Again, those constituted attorneys have further delegated their power to said Vinod Kumar Baid. I have given this, my lord. As per the communication by C. Vinod Kumar Baid, in which he stated that he is the constituted attorney of Vikas Chandra Sinha and Anindya Sinha, at the top of page 101 of the writ petition. 101, 106, 110. Whereas at the bottom seal and signature, it has been described as constituted attorney of the Sebais to the deity. No indication of power of attorney of the third Sebait. Now, the question now, submission has been made that one of the Sebait have died. That there is no whisper to that effect in the writ petition itself. Because admittedly, my lord, as on the day of filing of the writ petition, if out of 3 Sebais, 1 have died, then, my lord, it ought to have been referred to and indicated to. Today, for the first time, my lord, it has been submitted before my lord that one of the Sebais have died. Now, you will also kindly see the judgment I have given. The development agreement, my lord, that is also not disclosed. What is the development agreement with that Vinod Kumar Baid in the name of the company? That has not been disclosed. Now, you will also kindly see all those, my lord, important and vital documents have not been disclosed, which has a deep connection, my lord, with the instant issue, whether it would be, my lord, entertained at all or not. But I have raised an apprehension that in the guise of this, my lord, this property would be, my lord, sold or alienated or encumbered or transferred. Because in the long-term lease, the multi-story building is done, and with the help of the power of attorney or the development agreement, if it is sold but on a long-term lease, the property virtually will go out of the Arpannama or the estate of the deity. And Malala, in page 10, Malala will find in Roman 9, I have stated that deity is a perpetual minor and such permission from a civil code is a must for sale of any property or for development. But that is supported by 2016 Supreme Court Division Bench judgment. And I don't think, my lord, these judgments were considered by the Division Bench, my lord, where my lord was a party. All these judgments were not considered or my lord, attention was not drawn. And my lord, I have also stated how the estate, my lord, was done, and the deity has been recognized in the eye of law as a riot. That I have stated, my lord, in.
But if I have taken a view,
yes,
sitting in the division bench,
yes,
then where's the question of changing the view in the single bench?
No. Because, my lord, if that is, my lord, with greatest humility, I am submitting, my lord.
Then
That
this
judgment
should be heard by somebody else.
No. Yes.
Then the matter should be heard by a division different bench.
No. But after all these things, my lord can do this because, my lords are well empowered. My lord can observe that the factum of that case, the judgment, division bench, is completely different. It cannot be cited to be a precedent. My lord knows the salutary principles and the Supreme Court's judgment, my lord, the circumstantial flexibility. A difference in a single set of facts can make a world of difference. And these judgments were not at all, my lord, referred to before my lord. And
Mr. Banerjee, there's a problem. If I have taken a view in the division bench, then very difficult for me to.
This is not neither of us suggesting that your lordship is differing from a view of a coordinate bench.
No, I don't know. I have not really made up my mind.
Correct.
So,
that's different aspect. No, straight. If the division bench judgment is there, and if your lordship wants to disregard it, disregards it. But division bench judgment, irrespective of the composition of the judges, under Article 141 is binding. Your lordship would have had to refer it if what I'm saying, your lordship finds favor. There was a single judge decision, single bench decision, and your lordship was then saying that is per incurrum reference. Here, my lord, irrespective of who the bench is, it is binding. And not just that, my lord, I'll show this. Disregard that judgment, though that is the law, I'll show the statutory provision.
My lord,
Why your lordships have passed that?
2016
Why?
Calcutta, which I have referred to, it's also a division bench judgment presided over by my lord Justice Jyotirmoy Bhattacharya as acting Chief Justice.
So that there are several other judgments of
And
this
I have
honorable
given,
court.
my lord, all the judgments, my lord, of Calcutta High Court as well as, my lord, the Privy Council.
Let him finish.
What
my
I
lord,
have referred to are all other earlier judgments on different points. The points which I have raised, my lord, for my lord's consideration, on all those points, my lord, the judgments are there. I have referred to the paragraphs.
Mr. Banerjee, I am saying a different thing altogether.
No. What my lord is saying, that since my lord has taken a view,
Correct.
now my lord cannot deviate from that view, being a party to that. My lord, in my humble submission, there is no bar, my lord, bar in the eye of
No bar, I know there's no bar. You can always say this was not cited, that was
Yes.
not cited, but that's not right. That's not the correct way of looking at
Very
it.
well, my lord will then decide, my lord, whatever my lord will do. Only thing, my lord, I have handed over the judgment. My learned friends have also handed over the written argument, my lord. Have my lord, in that even, my lord, will
if I may
decide
just
what my
deal
lord
with
will do.
his written notes in exactly 2 minutes, my lord. We've also given a written note. My lord, district judge made law in an area that is covered by a statute is not to be given an expansive meaning. Disregards the judgments. Please have a look at the Indian Trust Act once. So that why your lordships have held that section 34 is not
Mr. Banerjee,
required.
I'm considering whether I should hear this matter or not.
My lord, in every matter, your lordship will find some judgment which is passed by a division bench.
Oh, that's a different thing,
It
Mr.
is-
Banerjee.
it is-
That's a different thing, Mr.
Well,
Banerjee.
irrespective of the composition, my lord, your lordship has heard it. But this is simplicity and binding. He's also relying on a division bench judgment. Well, if your lordship recuses now, well, there is really there is no personal conflict that your lordship has. It's a view that a court has taken. And I'm citing that view as precedent. But there is no conflict, there is no personal interest that your lordship has ever had with regard to section 34 Devottor. It's a view of a division bench of this honorable court. But if that otherwise in law weighs with this honorable court, then your lordship will follow that view, my lord. This has, then very few cases would a party get a chance to come before an honorable court.
একটা কথা বলে নি, তোর help এর জন্য। My lord, I was submitting, my lord, for both of us. My lord, the written notes on arguments of both parties are with my lord. My lord, kindly consider this. Then if my lord decides that my lord will not hear, then my lord will refer.
No. Once I've taken it, then I'll
My lord,
decide.
I will not take it that step
no
that
question of-
far. My lord, kindly decides it. My lord, this is a division bench judgment. The composition has
Show me
never.
the judgment of the division.
Yes. That composition has never been a.
Just show me the division bench.
Yes. That I had appeared for the respond number 5. Whether if that be the case, then I'll never be able to appear for another party. Here your lordship will find, Lord, paragraph 10, if I'm not mistaken. Paragraph 10. It was vehemently argued the permission to construct granted by the district judge was recalled. Perusal of the recalling order would show that the same was done on the premise that the order granting permission was not necessary. District judge observed a shebayat to a private devotor has unilateral right to make construction and no permission is necessary. Accordingly, the order was recalled. Well, this is the factual bit of it. Your lordship will now kindly turn over paragraph 13. It is true, presently the said order stands recalled, but the ground on which the same was recalled reinforces the right of the private respondents, that is the shebayats of the private devotor, to construct on the estate dehoors judicial permission. Subsequent recall therefore does not. Your lordships have only stated what the law is. And not just that, in our written notes, your lordship will find there are several other judgments that we've relied on which reiterates the same principle. And I'll just give your lordship the statutory background as to why your lordships have found this to be the law. Well, this is not a view. Court has expressed what the law is. And I'll tell your lordship why, my lord. If your lordship looks at the Indian Trust Act, I mean the Trust Act, my lord, but I don't know what the corporation means when it says that private devottor is something else. There is no other law that governs it. Kindly have a look at, my lord, section 1 of the Trust Act. May I just hand over, my lord? Please forgive my marking in pencil. Look, section 1, please have a look at, and I'll show the other division bench judgments of this honorable court. Savings will not kindly see. But nothing herein contained affects the rule of Mohammedan law as to waqf or the mutual relations of the members of an undivided family as determined by any customary or personal law, or applies to public, please mark the next two words, private, religious or charitable endowments. This is the analogy why 34 is not made applicable to private devottor, because section 1 carves out private, religious endowments or institutions outside this. This, your lordship will again find has been upheld by several decisions of this honorable court, which I have relied on, my lord. If your lordship looks at one of such judgments, Shokundra Devi, Lord, kindly have a look at paragraph 10 and 11 of this decision. Paragraph 10 and 11. It's a key to paragraph which name. Sorry, this does not have paragraph. Just give me a minute. Lord, we've given the 2009 9 SCC online calculator.
Just tell me the page number.
Your lordship will have a look at
the page number is on the top.
Page 3, last paragraph. The principal question is whether the Shebaites were required to obtain permission from the district judge concerned for alienating the property. As rightly submitted by Mr. Ghoshal, a complete answer to the question is available from the single bench decision of this court in Sri Ishwar Narayan Jew versus Soler. In that case, a Shebaite of the deity applied to the court for permission to transfer a part of the devotor as he needed funds for repairing the rest. His lordship held that a Shebaite, not a trustee in law, has to act for the deity according to the circumstances, and his dealings with the property vested in the deity are valid transactions. If they complied with certain conditions generally referred to as necessity, that there is no power in the court to grant an application filed by a Shebaite seeking sanction to transaction on the ground of necessity, and that there is no statute that deals with devotor, and that there can be no question of a Shebaite being appointed guardian of the property of the deity. In Sridhar Jew versus Kanta Mohan Mollik, a single bench decision of this court held that while there are similarities in the status of a minor and of a Thakur, they are both incapable of managing their property and protecting the interest. There are no dissimilarities. That is, the Indian Contract Act denies a contractual capacity to a minor, but does not extend that incapacity to a Thakur. Then your lordship will find, my lord, kindly the next paragraph. Line about 10 from top.
There is no provision.
That's right. There is no provision that obliges a Shebaite to take prior permission of any court for alienating a property owned by the deity. It is only that if the alienation is challenged at a future date, the alienee, in spite of the order, will have to prove as a fact that there was legal necessity for the transfer, or that he made enquiries and was reasonably satisfied the necessity of Shebaite. A Shebaite is not a trustee in the proper sense of the word, and the Indian Trust Act 1882 has no application to the case of a Hindu religious endowment. The court, therefore, has no jurisdiction to grant an application by a Shebaite to sanction his transaction on the ground of necessity. And this is thereafter followed. There is another judgment that we've relied on, my lord, which is 2019. Rishabh Rujana. And the corporation, well, a lot of argument has been advanced from the bar.
Can you read further? I'm therefore unable to see what basis the corporation concluded that the transaction, the same where you were reading. I am therefore unable to see on what basis the corporation concluded that the transaction. Page 4.
Yes, my lord. I'm so grateful, my lord. I am therefore unable to see on what basis the corporation concluded that the transaction under which the Shebayats of the DT alienated to the property to Jatan money could be entered into only if leave of the district judge Howrah was obtained. I'm so grateful. The question whether any legal necessity of the DT was the warrant for entering into a transaction could be raised only by one claiming interest in the property. And it is nobody's case that any successor in office of the Shebayats or any other person claiming any interest in the property ever questioned the validity of the transaction through which Jatan money acquired title to the property. I have not been shown any law that required the parties to transaction to obtain leave of the district judge Howrah. Therefore, I am unable to uphold the decision of the corporation that the petitioners purchasing the property from Jatan Mani's children did not acquire any title to claim ownership over it. In my opinion, the title lawfully passed according to the law. It is next sentence, my lord, taking a cue from what your lordship pointed out. It is therefore wrong to say that the petitioners did not acquire any right to mutation of the assessment regarding concerning the records concerning the property. Corporation even then, and my lord, if I, yes, even as on 2009, corporation took the same stand. Corporation here also has taken the same stand, my lord, if I may rely on one more decision of this honorable court. This is 2019 SCC Online Calcutta 998.
এই জাজমেন্টটা বোধহয় আগে দেখাচ্ছি কি নাম এটা
Copy down, sir. Kindly have a look at paragraph 9.
Applying this analogy, you will say that the letter which has been issued by them, where they are saying that the permission of the district judge is required, will not be applicable.
Yes. But if your lordship looks at paragraph 9,
yes,
Mr. Aniruddha Chatterjee, learned advocate for the petition at the outset, draws my attention to the order impugned. It is found from the said order that the learned district judge South 24 Parganas was of the view that as per the savings clause of section 1 of the Indian Trust Act, a private devotor estate is excluded from the domain of the Indian Trust Act. Therefore, an application under section 34 of the said act is not at all maintainable under the facts and circumstances of the case. The Shebayats, as a manager of a private devotor estate, is empowered to do whatever may be required for the benefit of the deities and devotor property. For the aforesaid purpose, permission of the principal civil court of the district under section 34 of the Indian Trust Act is not necessary. This argument, my lord, finds favor in paragraph 13, if your lordship sees. And if your lordship looks at paragraph 13, that is identical to what the division bench has held. Irrespective of the composition, your lordships have just laid down what the law is, keeping in tandem with the statutory scheme. And this entire argument that the corporation now has been advancing over days about devotor, what is the term, whether however much charm there is, you cannot travel beyond the order, not even by an affidavit, far less from the bar. The order, and in aid of that, we were relying on the most celebrated judgment we've met in of Mohinder Singh Gill. Mohinder Singh Gill will, for the sake of completeness, I'll just cite it. This is 1978, 1 Supreme Court cases 405, where your lordships have consistently held that an order will have to be justified on the strength of what is there in the order itself. It can't be supplemented, it can't be supplanted, it cannot be justified by an affidavit.
Yes.
তোমরা এখানে রিটার্ন নোটসে লিখেছো প্যারাগ্রাফগুলো লেখোনি? Well, if your lordship looks at paragraph 8, at page 417, my lord.
Yes.
The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to court on account of a challenge, get validated by additional grounds later brought out. We may here draw attention to the observation of Bose in Govardhan Das Bhanji. Public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer making the order of what he meant, or of what was in his mind, or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the actings and conductors of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself. And if your lordship looks at what is impugned here, the rejection has been on two counts. One is there is a suit pending, get that suit settled first, and second, get an order from a district judge. So this entire aspect of making a tremendous investigation, and I'm saying this very consciously, my lord, and not using the word inquiry. This investigation that the corporation starts making once the matter comes to court to justify an order based on what are the terms of Orponnama, and not once telling the court that the Orponnama grants me the right to sell the property. Vakalatnama signature is being looked at, and the most important clauses were not shown to the court. The translated version is before the court. In my written notes, I've identified it. The Bengali word is hostantor. The English word translation is there. The Orponnama gives that right to sell. Be that as it may, if I now come back to what the law has consistently been, keeping in view the statutory scheme also, this imposition of a condition by the corporation that I have to go and seek a permission under 34 is possibly not a legal requirement. As a Devottor, when I come before this honorable court, as a Shebayat, I have a right to do what is required without seeking judicial intervention, because the act has not been made applicable to me. Well, on a larger scheme of things, why the act has not been made applicable, that's a different aspect of it. But because there is no public law element involved. Unlike in a public charitable institution or a public religious endowment, where there is a public benefit involved, in a private, except my link with my God, there is no public element involved. So the statute does not come and govern what is essentially in the nature of a private contractual charter. This is the analogy why section 1 takes away private devottor. Because it's by way of a Orponnama it's given, which takes partakes the character of a private charter, of a contract. Statutory intervention has specifically kept out of the purview of a contract that I have entered into with him. Which is why your lordship has rightly pointed out, not private. Everything private is outside section 1. And like a fool, I missed the remaining part of that paragraph, which your lordship pointed out, which actually is the most important bit. Because the court delineates what is the jurisdiction that a corporation has in such matters. He cannot insist upon me to do something which is not the requirement in law. And corporation at all has absolutely no jurisdiction to investigate into the terms of an Orponnama. He can't sit there and when the statute doesn't apply, come and tell me, look, your Orponnama says this, you can't do that. With deepest of respect to his officers, they are incapable of ascertaining this. What? There is some officer sitting there. So these two things, my lord, first, with regard to the suit, that is gone. That's an admitted position, the suit is over. The second requirement which your lordship finds in the impugned order, which now, by how your lordships have traced the law, it can't be supplemented or expanded, is not a requirement in law at all. All his judgments, which he very cursorily relied upon, we've dealt with paragraph-wise, my lord. Most of them are, I've dealt with it, my lord, they're actually irrelevant. If your lordship takes up most of the judgment that was cited, they were all relating to a scheme with a public charitable institution that were filed before this honorable court, asking the court to frame a scheme without actually adverting to the situation of section 1, which is excluding private.
May I?
Yes.
Three counts. I have.
It is finished.
One aspect I'll just show. My lord, to highlight one thing, my lord, just malice in law. And this ought to have been pointed out. My lord, this is a 25th August 2021 circular issued by the government of West Bengal. Please have a look at the subject. Alienation of private Debotto land. With reference to the above and the resolution of the meeting held on 11 January 2021 in this department, the undersigned is directed to state that the matter was referred to a learned remembrancer, and after careful consideration of the matter and the orders of different courts, it has been opined that no permission is required in case of private Debotto properties by Shebai for legal necessity and for the benefit of the DT. So this is the government of West Bengal stand. Corporation insists I go under 34, take a permission.
Yes.
Well, these are my respectful submissions. Let him not, there can't be a reply to a reply.
No, it's
He's
not a
argued
reply
for
to
4
reply.
days. Everything else, my lord, is in the notes. I'm sorry, your lordship has actually had to spend a lot of time on this.
My lord, 3-4 submissions my learned friend made. I need to respond.
Yes.
The first thing, my lord, my learned friend has submitted that the Orponnama authorizes them to do so. Now, kindly come to my lord page 85. It's a Bengali document. Translation is there. Kindly come. It's a Bengali document. My lord, translation has been handed over. It's a rectified.
He should get the satisfaction.
Yes, yes. That's true. That's true, my lord. That's true.
Yes.
I should be satisfied. My lord, kindly see.
Yes.
সম্পাদন কালে, মানে I'm reading from page 85, last 4 lines. উক্ত দলিল সম্পাদন কালে সেবায়েতগণের ক্ষমতা, অধিকার আদি লিখিত আছে। যদিও সম্পত্তি সেবায়েতগণ কর্তৃক ভাড়া বিলি দ্বারা নানাভাবে আয় বৃদ্ধি করার ক্ষমতা লিখিত আছে, কিন্তু লিজ ফর এনি পিরিয়ড বা লং লিজ দিবার কোনো ক্ষমতা স্পেসিফিক্যালি লিখিত নাই, এবং উদ্বৃত্ত স্টেটের উদ্বৃত্ত টাকা।
There's an English version of this.
I'm coming. The English version is there, but I'm just saying, my lord will find from the English version. It's that there is no written authorization of giving lease or long-term lease to anybody. But it has not been disclosed under what development agreement it is linked, long-term lease or otherwise. It would be there. I think.
Factually, may I just correct him once with extreme humility? For all this time, he argued rectification of the deed could not have been done. He's reading the rectification. I am showing your lordship the main parent Orponnama.
Then why it has been disclosed? What is there?
What is the corporation doing?
No. What is the reason? No. Everything, my lord. My lord, this is one aspect of the matter. This is one aspect of the matter, my lord. It amply demonstrates that in the original deed of Orponnama, even I can show that there is no authorization of lease or long-term lease or otherwise.
See, Mr. Banerjee, either the rectification could not have been done,
Yes,
Or the-
rectification could not have been done by third
But
person.
you are
After,
relying on the rectification.
no, but if your lordship will kindly appreciate, once a property is vested on a deity, the erstwhile owners have lost all their rights. What are the writings, my lord, in the deed of Arpanama? The Sebayets appointed are strictly bound by that. They doesn't become, they do not become, my lord, owner of the property. They are simply manager. I have given the judgments, my lord. What the Sebayet means, not of 2 days, my lord. The legal luminaries and this, my lord, celebrity honorable judges were there, my lord. I have given all those things. Even, my lord, your lords will kindly see. At a point of time, one judgment I have given that if there is none, who will look after that? But there it has been held that the crown will look after that. Obviously, my lord, it's a pre-independence matter. Crown will look after them. Now the crown can be substituted by the government itself. The government will look through whom? Through this judiciary. It is the position what I have given. I have argued, my lord. Now, the other thing I do not know how my learned friend will overcome this. That, my lord, Wakalatnama was given to a person by the constituted attorney.
He's argued all this. I have dealt with this in
No,
the.
you have said many things, my learned brother. Everything I have said trash since my lord, since my lord is allow me. Allow me.
I'll listen.
I'm making a trash submission. All right, no problem. Now your lordship will have to consider the basic foundation, that whether that can be done at all or not. If it is not there, if it cannot be done.
You're sitting there and you're losing your patience. I'm sitting here.
Yes.
But I agree.
My lord will kindly consider whether, my lord, a delegate can further delegate his power or not. Your lordship will kindly appreciate this. This is one aspect of the matter. The other thing, my learned friend has submitted that, my lord, government's notification of 2021. It was given by a single judge judgment. My lord, again, I am repeating at the risk of repetition. My lord, the judgments which are cited by my learned friend are factually, my lord will find all the facts and circumstances are not the same. And I have also relied upon the division bench judgment and some single bench judgments, as well as, my lord, the Privy Council's judgment. But everything is there, wherefrom my lord will find that this principle is there. Even a full bench judgment of my lord, Gujarat High Court, my lord, I have given, wherefrom my lord will find that the principle of delegatus non-potest delegare, my lord, squarely applies here. If it is not there, then the entire writ petition fails. That is my submission. Your lords will kindly consider. I have handed over the judgments. And one more thing, my lord, I have also given, my lord, the doctrine of precedence. And the judgment I have there, I have stated everything. Your lords will kindly consider this aspect of the matter.
All right. Take written notes filed by the parties is taken on record. Matter heard. What do you call saving?
Very grateful.
আমার আছে আরেকটা না না আমার আরেকটা আছে
अरेंज कर दें अरेंज है ना इट सेंड इट
না But I appear for the municipality.
Fresh matter?
Yes.
My lord, being taken up for the first time.
Yes, my lord. Because it's a history, my lord. A building plan was.
What is here?
No, nobody is there. Well, I'm just one minute submission. A building plan was obtained, my lord, by suppression of material fact. Subsequently, my lord, it was cancelled. It was cancelled, my lord. A writ petition was filed. The Honorable Court, my lord, in 2003 itself, my lord, submitted that since there is a question of false or misrepresentation and all these things, and he has made a representation, that representation should be considered and order should be passed. This was the order. Until then, status quo is there. But since then, my lord, no representation is there, save except one line representation of permission for boundary wall. And in so far as the building plan for one-story building, my lord, it was already uploaded in the my lord online. That my lord, the bill, all the papers were not submitted. That documents, web-based documents, I have, my lord. This is the case, and he has stated that representation has not been considered. I can show, my lord, that only one page, 2-3 lines are there. Since my learned the read petition is not there, my lord, I am not drawing my lord's attention to that effect.
All right, not today.
Yes.
Not today.
Lord, I appear for the state.
I am for the respondent number 3. Respondent number 3, I mean railway.
তুমি তো সাপোর্ট করছো।
কি সাপোর্ট করছি? সকলকে করছি।
দিয়ে দাও, ফাইল করো।
I hand it over
আমার
to
নয়,
the-
municipality আছে।
আমি জানি।
তুমি যাও, ওইদিকে যাও, এদিকে যাও। 28
municipality তুমি বলো, ডক্টরকে বলো তুমি। এখান থেকেই বলো।
My lord, for the municipality, my lord, as similar as item number 15, my lord, I'm paying for 1 week adjournment, my lord.
All right, we can't say no to her. We can't say no.
Anything, my lord, may I submit my opposition on behalf of the railways?
Please, file করে দাও। The pleadings are complete, not in place for hearing.
Affidavit, you want to file your
We have also filed reply.
affidavit in opposition filed by respondent number 3 is taken on record. A reply to the affidavit of respondent number.
Professor, municipality to me.
Reply, affidavit in reply
আমাকে এটা দেবে তো?
by the petitioner against the affidavit in opposition of respondent number 4 to 7 is taken on record. This is respondent number 3.
Respondent number 3 is railway.
4 and 7.
My opposition is interested in municipality's affidavit, not railway.
Not to, that's what I'm asking, Mr. Bhattacharya. You want to file your?
Yes, we shall. So for the railway is concerned, we shall file affidavit.
Yes, that's what. Learned counsel for the, learned senior counsel for the petition, Mr. Vikas Ranjan Bhattacharya, seeks and is
The
granted.
state is represented, but no affidavit is required from the state. দরকার নেই বলে।
Seeks and is granted. How much time, Mr. Bhattacharya? 2 weeks?
2 weeks.
2 weeks time to file his reply to the affidavit in opposition of respondent number 3. Let this matter be listed on even December.
কবে থাকবে?
তবে 17 কি?
8 December.
ডিসেম্বর? হবে না, সময় জানো।
नहीं, इसको कर दो
এমনিতে এটা বন্ধ আছে তো।
2nd December.
জানি ভদ্রচন্দ্র সরি অ্যাপিয়ার করি।
2nd December.
2nd December.
Second December.
Second. চলো রেলওয়ে।
দেখো তো তুমি এই কি সব করছো, তুমি তার রিপ্লাই দেবে কেন?
এক্সটোল
তাই না?
Item number 29, I'm appearing on behalf of the petitioner, your lordship. This is that matter where the street vendor was evicted and the street vending stall was confiscated. So on the last occasion, the KMC was instructed to bring instruction regarding the street vending stall. So
I beg to appear on behalf of the state.
Hello, who's for the KMC? You were supposed to.
Yes,
what happened to his stall?
My instruction is that it has been
confiscated by police and police has been directed to return it, my lord.
And our instruction is that it has been taken by the KMC itself. We assisted in them. This is the report.
Is this? Who has taken the stall?
As per our report, it's by the officer in charge, Southeast Traffic Guard. It has been taken by the KMC personnel during the drive, encroachment drive.
No, this can't go on. Mister,
Yes, my lord.
this can't go on.
But this is the instruction, my lord. If your lordship kindly allows me some time, my
I'll
lord.
call
so that-
both the officers.
Yes, madam, that's why I'm saying. Well, kindly allow his to give a copy of his instruction, my lord, so that we can
You
take
take
up
the
this.
instructions, I'm keeping it next week.
Yes, madam.
Whatever it is, don't force me to pass orders against
My
them.
lord, my lord. My lord.
This can't go on.
Yeah, Lordship.
You sort it out between yourselves,
This is totally
and I want an answer to this.
Yes, this is totally contradictory. I don't know. I will check it out. Definitely.
You're filing these affidavits in High Court?
My lord, I'll definitely take.
How can your officers do this?
There has to be something in between.
My lord, drive was taken
It's a
up.
ping pong ball.
My lord, the drive was taken up with the assistance of police, my lord.
Sort it out and come back to this court.
My lord.
We'll keep it next week.
Grateful.
And I'm not taking it. If I take it, I'll pass adverse orders against you.
My lord.
Use your good officers, both of you. Not today. Keep it next week. Rest of the matters tomorrow.
The matter is important, not today.
Not today.
Not today only, not today only.